Peace, love, and prosperity to all of humanity on Midgard, planet Earth. Today we'll be discussing the Treaty of Madrid, amongst other documents, supporting documents. And we've already covered the Treaty of Madrid, but it's I feel that covering it again would make more sense. Plus redundancy is good anyhow, but seeing as though we went over the France versus United States case, the Protectorate, and basic information on what on French involvement, I thought the Treaty of Madrid would be germane to go over, especially as it relates to certain documents, such as the expatriation document with Hoffman Phillip, even your famous AA 222141. What is it actually coded as? Chapter 22, Title 2, sections 141 to 143. The CMB number. So welcome. This is AMPAG Media. With our roundtable session. I'm here trying to share my screen. You know, I'm not good at computer work. Okay, here we are. So we'll go right in to our famous 222141. It's actually Public Law 856, or actually coded as 8 stat. What is it? Where is it? Yes, 8 stat 48434 stat 2905. Let me load this up a little bit. All right. Right here. 8 stat 48434 stat 2905. Joint resolution. This is what Moors, we've went over this document before, but we didn't go over it with the proper concept and the proper understanding because we didn't understand international law. If you didn't know or understood international law, you wouldn't know where a lot of the language came from that they were using in this particular bill. It's a bill, by the way, legislation, and it has passed since 1956. This is from the legislative branch, House of Representatives, as I'm showing you here. This is an official document. Moors know about this document, but for some reason, Moors can't read. I remember watching Moors go over these documents on YouTube, or this document. So let's try to read it and see what it says. But let's complete the reading and not stop short of the reading, right? So let's start from the very beginning. Public Law 856, Chapter 807, August 1st, 1906. Joint resolution approving the relinquishments of the consular jurisdiction of the United States, where? In Morocco. It's in Morocco. You'll see a repetitive, you'll see that coming up quite often today in Morocco. Approving the relinquishment of the consular jurisdiction of the United States in Morocco, whereas the laws of the United States invest the ministers and consuls of the United States in certain countries, including Morocco, with judicial authority so far as the exercise of the same is allowed by treaty, right? With judicial authority so far as the exercise of the same is allowed by what? Treaty with such countries, and in accordance with usage in such countries, and whereas the consuls of the United States in Morocco are permitted to exercise jurisdiction over American nationals, keeping in mind we're not American, under the treaty between who? Who is the treaty between? Okay, so this is the United States talking. The United States and Morocco, signed September 16, 1836. Which treaty is that? Obama gave a speech in Al-Kibbuline, Egypt, Kemet, in what was that, 2012, I believe, in which he reaffirmed that Morocco was the first country that recognized the United States of America as a sovereign country. They all have. Through what? The Treaty of Peace and Friendship. Between who? The United States of America, the proper signatory power, not the United States, it's the United States of America, and Morocco, and the Sultan of Morocco. Therefore, the treaty is between who? The Americans and the Moroccans. This is too simple. I don't understand why we're making this too, so difficult, so hard, so complicated. It's due to confusion, COINTELPRO operations. You got to get past it though. Under the treaty between the United States and Morocco, signed September 16, 1836, they're not finished. There's more. And the Act of Algeciras, signed April 7, 1906. And the exercise by custom and usage, we went over that in the France versus United States case. The United States was trying to claim customs and usage. And the ICJ judges rejected it. The same jurisdiction over subjects of Morocco. I mean, it's a matter of proper interpretation, I suppose. So shout out to the good brother Jay Bay from AMPAG for giving us the proper interpretation and the proper reference points to really understand this legislation. Because without the international law reference points, without the treaties, the Moroccan treaties, we wouldn't know where they got these terms from. Where did they get the word subjects of Morocco? And more importantly, what does it mean? If an NBC reads this bill, he's going to be confused. He's going to think that they're talking about Morocco across the water, right? But us Moors, who have come into the light through the Moorish Science Temple of America or the Moorish movement in general, we know that Moors are Morocco. You can't even spell Morocco without the word Moor. M-O-R. So, backtrack. And the Act of Algeciras, signed April 7, 1906, and the exercise by customs and usage, the same jurisdiction over subjects of Morocco or others who may be designated as proteges. Another word that's coming out of the treaties. Under the convention of, here we go again, another treaty, Madrid. The Convention of Madrid, signed July 3rd, 1880. So they just regurgitated 3 different treaties on that one paragraph. the Treaty of Peace and Friendship, the Act of Algeciras, and the Treaty of Madrid, which is what we'll be going over today. Whereas Morocco is now the only foreign country where the consuls of the United States exercise such jurisdiction. I don't know what Moors was reading. Whereas Morocco is now the only foreign country where the consuls of the United States exercise such jurisdiction. And whereas it is the policy of the United States to discontinue the exercise of extraterritorial jurisdiction in Morocco. See, you stop here and you don't read the whole thing, or vice versa, right? You don't, but see, there's more down here though. And so if you read this, whereas Morocco is now the only foreign country where the consuls of the United States exercise such jurisdiction, and you leave it at that, you're going to think that that's in force and it's in stone, written in stone, right? But then it also comes back and say, whereas it is the policy of the United States to discontinue. But why are they supposed to discontinue the exercise of extraterritorial jurisdiction? Because of the judgment of the ICJ. They're not supposed to continue on with it. They're supposed to relinquish it, right? That's why they had to create this legislation. But by 1937, all the other signatory powers of the Act of Algeciras had already relinquished jurisdiction in Morocco. Because remember, there's 13 signatory powers or 13 parties to the multilateral contract. That's why it's a multilateral contract or treaty. Russia, Spain, Great Britain, France, United States, etc., and then Morocco as the dominant power in the contract or on the contract, because it was the Sultan who summoned all the foreign powers. It was his Sharifian, His Majesty, the Sultan of the Sharifian Empire, who summoned all the signatory powers to a round table to put these laws on them. You put these laws on them. Whereas it is the policy of the United States to discontinue the exercise of extraterritorial jurisdiction in Morocco at such time as it becomes appropriate. Right? So they're going to maintain the exercise of extraterritorial jurisdiction. It's against the policy, but they're going to maintain it until the time that is appropriate. So they're in limbo. They're, you know, we're ready to discontinue extraterritorial jurisdiction, but only until the time that's appropriate. Well, when is it? When is that time? When is the time appropriate? Therefore, be it resolved by this. And by the way, this is what we got to learn: how to write laws, how to write legislation. This is the process in which we're under. This is what we're working on, learning how to write legislation. So the Lil Aziz, pay attention to this document, the structure and etc. Matriarchs. Resolved by the Lil Aziz, right, instead of the Senate and House of Representatives. So the way we would say it is resolved by the Lil Aziz or Matriarchal Council of Alodia Morris Paredia Monte, Georgia. Right, but this is the United States. So the way theirs are worded, resolved by the Senate and House of Representatives of the United States of America, right, of America, the Americans in Congress assembled, that the relinquishment by the president at such time as he considers this appropriate of the consular jurisdiction of the United States, where in Morocco is hereby approved in sections 1693, 4083 to 4091 inclusive, 4097 to 4122 inclusive, and 4125 to 4130 inclusive of the revised statutes as amended are repealed effective upon the date which the president determines to be appropriate for the relinquishment of such jurisdiction. So it's when the president determines to be appropriate for the relinquishment of the jurisdiction, of such jurisdiction, except so far as may be necessary to dispose of cases then pending in the consular courts in Morocco. So this was approved August 1st, 1956. And the president hasn't signed it yet. So they have been maintaining, due to that fact and that fact only, that's it. That's the only reason why they continue exercising extraterritorial jurisdiction, because it's not fully, it hasn't been fully ratified by the president. It's only in such time as he deems is necessary. Well, when is the time necessary? When the Moroccan government tell them to do so. Simple as that. So AMPAG is getting ready to send Joe Biden a judicial order. New Mecca is getting ready to send Joe Biden a judicial order. AMPAG is also getting ready to send Joe Biden a judicial order. But they'll be sending theirs first. You know, Jay Bay is the chief judge of consular court over there. He would be preparing that document, letting Joe Biden know that the time is now, according to 8 stat 484 34 stat 2905, the time is now for you to relinquish extraterritorial jurisdiction in our Utipazidated jurisdiction. That would be AMPAG, or what's formerly known as Colorado for AMPAG. Utipazidated is a longitude, latitude coordinates of their jurisdiction, their borders. They don't have to do it for Wyoming. They don't have to do it for New York. They don't have to do it for any other territory. But they damn sure got to do it for AMPAG. It's an order from consular court. And if they don't obey, of course, after going through due process, then you bring in the ICJ. Take them to court. So you see right here, 22 USC 141 to 183. This is your AA 222141. There's another one that's coded, that's written a little differently. But it basically says the same thing. So over here, you see all this in Morocco. We've went over this before. This is Mr. Philip, the Chargé d'Affaires to Mr. Root, Secretary of State, August 3rd, 1906. American legation. The American legation, we went over that. That was in Tangier, August 3rd, 1906. That's like it's a form of an embassy, an American legation, right? So the American legation belongs to the United States of America. And the American legation is in Morocco. The legation belongs to the Americans. Who are the Americans? The United States of America are the Americans. Who are they? The foreign powers. Who are we? The landlords. We are the autochthonous, Aboriginal and Indigenous Moroccans. We are not the Americans. They are the Americans. So they required an American legation in Morocco. Come on, Moors. It's that simple. Sir, there are strictly speaking no Moroccan laws, no Moorish laws relating to citizenship of Moorish subjects where? In Morocco. The fundamental laws of this non-Christian country are based entirely upon the Islamic code, no part of which treats of the subject of citizenship. We're not citizens. So our non-Christian country was entirely based upon the Islamic code, no part of which treats of the subject of citizenship. That's why the terms that they used in the treaties was subjects. Either you're a subject of Morocco, which means you're subject to the crown, which means you're in your sovereign jurisdiction, or you're a Moorish or Moroccan subject, which means then you will be subjugated to a foreign country. Two totally different legal personalities. Subject of Morocco, or you can say subject of Great Britain, or a British subject, same difference. So a subject of Great Britain could end up being a British subject in China, right? Excuse me. So the subjects of Morocco, at the time we were subjects of Morocco because it was a monarchy. It made us subjects of or to or whatever. really of, because it says right here, of, so it's of, subject of Morocco. We became subjugated as subjects, as Moorish subjects or Moroccan subjects. And that's the proper political status for Black people. It ain't Black people. It ain't Negro. It ain't colored. It ain't African American. It is none of that. It's Moorish subjects or Moroccan subjects. But knowing that would have you hanging around too close around the truth. So they had to distance us away from that particular truth because it's bringing us too close to their pain points. That was their pain point. That's why the 14th Amendment, as the good brother pointed out, omitted the word subject out of the Constitution. Amended. That's what an amendment is. An amendment is just, in a contract, when you amend the contract, you're revising something, changing a word, sentence, paragraph, whatever, title. Well, they were removing the word subject because that, I forgot the article, but it talks about citizens and subjects. We weren't citizens, we were subjects. That's why Dred Scott was found as a plaintiff in error. Because at the time, that's the reason why they did what they did. Because at the time, Dred Scott was a subject. All the Dred Scotts of the world, all Black people, all the subjugated Moors were Moorish subjects. So therefore, they were known as subjects. The 14th Amendment removed the word subject and turned us into citizens. So that now they can have civil and criminal jurisdiction over the subjects. Because until then, they did not. Why? Because the subjects, due to that particular political status, they had the sovereign right to not only the obligation, it was the only way they could operate was to petition consular court. That's why he was a plaintiff in error, because he petitioned the Supreme Court of the United States. He was supposed to petition the consular court of Morocco. He was supposed to go to the Moxen. He was supposed to go to the Moroccan government. Why? Because of this right here. This is the Treaty of Peace and Friendship. Can you all still see my screen?
As long we still see it, right?
Okay, good. This is the Treaty of Peace and Friendship, 1836. Article 20, if any of the citizens of the United States or any persons under their protection shall have any dispute with each other, right? So Dred Scott, I forgot who the guy's name that Dred Scott had the problem with, but Dred Scott had a problem with a United States citizen. That's why he was trying to take him to court. That represents that first line right there. If any of the citizens of the United States or any persons under their protection. So that guy that Dred Scott was taking to court was the citizen of the United States. And Dred Scott himself was a person under the protection of the United States as what? A subject. And then it says, shall have any dispute with each other. So Dred Scott and that US citizen had a dispute. That's why he was taking him to court. But what happened? He took him to the wrong court. He took him to the Supreme Court of the United States. That's why he was found as a plaintiff in error. Because what does the treaty say? Shall have any dispute with each other, the consul shall decide between the parties. He was supposed to take him to consular court. It says it right here. This is Dred Scott all day. So the United States, so the citizen of the United States was the guy that Dred Scott was having a problem with. And then the person under the protection of the United States is Dred Scott as a subject, a Moorish or Moroccan subject, a subjugated Moor. And if they had a dispute, which they did, then the consul shall decide between the parties. And whenever the consul shall require any aid, our assistance from our government to enforce his decision, it shall be immediately granted to him. That deals with that's dealing with Article 20 of the Treaty of Peace and Friendship. Right? So they omitted the word subject. They turned it in, they turned us into citizens through the 14th Amendment, which then made us Americans. Little brother Asir the Duke of Tears, I saw a video last night. He said that we are the most patriot, the Moors are the most patriotic Americans. I went like, I cringed. We are the patriots, the patriots. The Moors are that we are the patriots. This is what he was saying. The American patriots, the true American patriots. I was like, wow. He didn't read what this is saying. That there, strictly speaking, no Moroccan laws relating to the citizenship of Moorish subjects in Morocco. The fundamental laws of this non-Christian country are based entirely upon the Islamic code, no part of which treats of the subject of citizenship. Right? We're not citizens and we're not Americans. We are subjects, Moroccan subjects, or we are Moroccan nationals. It's really only, that's it. So that's their pain point. Their pain point is you operating in your proper capacity, in propria persona, sui juris. What is in propria persona, sui juris? Moroccan national. I'm gonna show you. There are, however, numerous treaties and conventions between the various Christian countries and the Moorish Empire, by means of which citizenship in this country is defined. But as I understand from the above acknowledged instructions, that it is not the desire of the department to call for a report upon such lines. I will therefore continue these remarks to general conditions existing, which may possibly be of some use in connection with the information desired. 1, citizenship in Morocco. In Morocco. Where else do we hear? How often, how many times do we see in Morocco here? They ended this with in Morocco. In Morocco. How many times must they say it if it ain't enough for the Sultan to say it, for the treaties to say it? Over here, in Morocco. In Morocco. There's no way around it. We're in Morocco. Why is that so hard to comprehend? Citizenship in Morocco may be said to be governed by the laws pertaining to the same in other countries, with the exception that all persons residing in Morocco who cannot prove foreign citizenship or protection are considered ipso jure as Moorish subjects. That was the name of the video on why are we Moorish, ipso jure Moorish subjects and how not to be. I already went over this. Go over it again. Redundancy is good, because maybe you didn't get it the first time, right? So if you cannot prove foreign citizenship or protection as a Moor, then you are a Moor subject. How do you prove foreign citizenship and protection? You need your emanating documents that show and prove who you are, that's been issued to you by who? Your Moorish state. These are like the building blocks of statehood. This is like this is like kindergarten. Simple. It's not even that complicated. These are the ABCs of statehood. We're just getting started. Relearning our ancient principles. We set all this up. We know how this stuff works. We just went to sleep for a little while and forgot. So you need your state ID. If you're a diplomat, you need your diplomatic bag. You need your emanating documents, your certificate of live birth. Eventually, we will be moving into passports. This is how you prove. And it's got to be a competent state, not just some chartered, registered under the United States Secretary of State type. No, it's got to be a competent state with a ratified constitution that has been deposited and promulgated. Autonomous, sovereign, and independent. You must adhere to the triple principles, the 3 clicks in Dorothy's heels with her cherry red slippers, the cherry tree, the Moorish Empire flag. And it's not a national flag. Moors call that flag a national flag. That's not the national flag. That's an international flag. Stop playing. 3 clicks: sovereignty and independence, integrity of domains, economic liberty without any inequality. The triple principles. The first one, sovereignty and independence, establishing your states under the strict sense of international law. Got to follow the rules and procedures, the direction. We can't come up in here trying to make up our own rules because we Moors. Got to do things the right way. And that's how you prove foreign citizenship or protection, so that you will no longer be what? A Moorish subject. You will now be what? A Moorish national, Moroccan national. 2 and 3, Moorish subjects lost their nationality only by becoming naturalized in or protected by the United States. It says another country, but the United States. Having treaty relations with the Moorish Empire, with their own empire. So Moorish subjects lost their nationality only by becoming naturalized in or protected by the United States, having treaty relations with their own empire. They could have just really said that. What's the treaty relations? Okay. What did they say over here? Over here, they said United States and Morocco, 1836, that's the Treaty of Peace and Friendship. They said the Act of Algeciras, 1906, and then they also said the Treaty of Madrid, 1880. That's the treaty relations. It was established by the Convention of Madrid, concluded July 3rd, 1880, as follows. Article 15 of the Treaty of Madrid, any subject of Morocco. So what did he say up here? Subject of Morocco. There are, strictly speaking, no Moroccan laws relating to citizenship of Moorish subjects in Morocco. Subjects in Morocco, subjects of Morocco. Over here, they said what? Did they say subjects of Morocco here? I'm not sure they said that here. But that's what it is. We're subjects of Morocco. Yep, he damn sure did. And exercised by custom and usage the same jurisdiction over subjects of Morocco. So they're exercising their extraterritorial jurisdiction under customs and usage over subjects of Morocco. Right? And he over here said that Moorish subjects lost their nationality only by becoming naturalized in or protected. So we became naturalized. Nobody knew they were naturalized, right? There was no consent from a Moroccan government or any individual for that matter to become naturalized. So we were naturalized in fraud, right? We all know that. That's pretty common within the Moorish movement. We were naturalized against our consent. So then clearly the Sultan felt compelled to do something about that. So he created Article 15, or they wrote Article 15. And it's like, okay, so since you want to naturalize the Moors against their will, then here you go, Moors. Here's some assistance. Any subject of Morocco who has been naturalized in a foreign country, the United States, and who shall return to Morocco, shall, after having remained for a length of time equal to that which shall have been regularly necessary for him to obtain such naturalization, choose between entire submission, the whole thing, the whole shebang, not a part of it, all of it, entire submission to the laws of the Empire of Morocco, and the obligation to quit Morocco, unless it shall be proved that his naturalization in a foreign country was obtained with the consent of the government of Morocco. Well, we already know that there was no consent from the government of Morocco. So they naturalized us, and the Sultan came back and said, okay, I got something for you. Any subject of Morocco who has been naturalized in a foreign country shall choose between entire submission to the laws of the empire. Come back home, Dorothy. The Rock of Salvation, Al-Marak. United States, cares of the world. The Rock of Salvation, Al-Marak. Morocco. The one-on-ones hit different. That demonstration on the one-on-ones hit different when you understand Article 15. This is Article 15. This is Article 15. The prophet is stepping out of the cares of the world. That's America, onto the Rock of Salvation. That's Morocco, carrying who? The mother, the matriarch. You can't tell me the prophet wasn't reading these things, that he was oblivious to international law. How could that be? He's the prophet. You really think he was oblivious to international law? This is the demonstration of Article 15. That's the demonstration right there. Because guess what? This is what happens to you if you don't choose between the submission of the laws of the empire. Foreign naturalization, they're heretofore acquired by subjects of Morocco, according to the rules established by the laws of each country, shall be continued to them, right? So those laws that's established by the rules and the laws established by each country, what countries? United States, Great Britain, Spain, France, etc., Germany. Those are all the signatory powers. That's why that's why they're using words like foreign country and general terms. They're not specifying the United States, because this could have happened to Moors in Spain. So he's generalizing it based on the signatory powers that are part of this treaty. So then it goes, foreign naturalization heretofore acquired by subjects of Morocco. So those subjects of Morocco that ended up being naturalized, according to the rules established by the laws of the country, shall be continued to them as regards all its effects without any restrictions. What did we do? We acquiesced and remained in America, the cares of the world. And because of that, now the rules of the country shall, in all its effects, can be imposed upon us basically without any restrictions. But then what happens when you choose between the entire submission of the laws of the empire? It all stops. And you take back now your rightful place in the affairs of men. Which means now the foreign power, according to the same treaties that they have been speaking about, Treaty of Peace and Friendship, Act of Algeciras, Madrid. Now we impose those on you as it's supposed to be. That's trading places. Eddie Murphy, or really trading places back to where we were in the first place and where we're supposed to be in the first place. Enacting laws, legislation, governing the system that's currently operating in Morocco. What's that system called? The United States. That's what decolonization looks like. Us governing, managing the entire operation, the public works and services, the guns, the banks, the taxes, the military, opium and kif. We govern all that on behalf of the empire as the Moxen or the state governments. That's what decolonization looks like. It's not a matter of kicking them off the land or enslaving them. That's why you can't come at this. We can't come at this in the spirit of hate. We've got to come in the spirit of love, right? We got to learn to love instead of hate. We can't come with this revengeful energy, this radical, crazy energy. We've got to come at this thing with a level-headed mind on the love, truth, peace, freedom, and justice, diplomatic relations. So you walked us across the trails of tears. Okay, we walked y'all across the hot Arabian desert for 2,200 miles. Okay, we're even. Where's the rent? Where are the taxes? Where are the duties? The tributes? That's what we're worried about. Take over the system, control, manage, operate the system, govern them according to the Treaty of Peace and Friendship, according to the Treaty of Madrid, according to the Act of Algeciras. That's economic liberty without any inequality. That's the last of the triple principle. That's why integrity of domain has got to be solid. That integrity of domain deals with the laws, enacting laws, consular court operations. Because what's their pain point? Moroccan nationality in combination with consular jurisdiction. They don't want that. And obviously, in order to have a consular jurisdiction, you got to have a competent Moorish state. Because consular jurisdiction comes through the judicial branch. This is not really that difficult to recognize and understand. These are building blocks. The above ruling has never yet been acted upon. That's what he said. We haven't acted upon it. You know, just whatever. The above ruling has never been yet, has never yet been acted upon. And should at any time be contemplated seriously, a large number of naturalized people, American and others, residing in Morocco will be affected thereby. Residents, residents in foreign parts does not affect the nationality of Moorish subjects, and the Moorish government has no means of protecting its subjects permanently residing in other countries, with the exception of a so-called Moorish consul at Gibraltar and a Moorish agent at Cairo, Egypt. I am ETC. Hoffman Phillip. He's probably chubby too and pale. But let me stop. I was just being funny. But yeah, so you see the correlation between these two. I mean, it's like it's the United States, it's the colonizers, which you might deem as your enemy. This is what they know about you. So while as a people, we might be all confused, running around like chickens with our heads cut off, not knowing who we are, you know, we've got all types of we got an identity crisis. We're the Olmecs, we're Egyptians, we're Hebrew Israelites, we're Cherokee, we're Indian, We're American, we're Moorish American, we're African American, we're Pan-African, we're Black Panthers, we're gods and earths, we're a nation of Islam, we're Moroccans. You want to simplify this? You want to clarify this? You want to focus in on one thing and ride that one thing to the final destination? Moroccan. Period. This settles your confusion. Moors, Black people, NBCs, Asiatics, Hebrew Israelites, everybody. This simplifies it for you, but are you willing to read and get the proper concepts? Treaty of Madrid. So these are the signatory powers: His Majesty the Emperor of Germany, King of Persia, Count Albert de Solms. I'm not going to read all of this. So a lot of it is hard to pronounce because it's all these foreign names, and it's really their what do you call them? Plenipotentiaries, ambassadors, minister of foreign affairs, etc. It's not the country itself. There are some interesting names here, though. You have Sidi Mohammed, Talib Sid Mohammed Vargas, His Majesty the Sultan of Morocco. That was his name at the time. All right, Talib Sid Mohammed Vargas. And these are the other plenipotentiaries and ambassadors and etc. So you always want to start with the preamble. So all these people representing 12 different states say that who, in virtue of their full powers, recognized as being in good and due form, have agreed upon the following articles. It says that they're recognized as being in good and due form. That means they're on point with what, with their ratified constitutions. There are competent states, basically. Article 1, the conditions under which protection may be conceded are those established in the British and Spanish treaties with the government of Morocco and in the convention made between that government, France, and other powers in 1863, with the modification introduced by the present convention. Article 2, foreign representatives at the head of a legation, just like the American legation. Foreign representatives at the head of a legation may select their interpreters and employees from among the subjects of Morocco. So they can, select their interpreters and employees from among the subjects of Morocco. You need interpreters, you need employees. We'll talk to those Moors, those subjugated Moors. It gave them permission to go get whatever from subjects of Morocco, employees and interpreters, or others. Okay, every time I move this, oh, okay, I have to work with this document. All right, the protected persons shall be subject to no duty, impost, or tax, whatever, other than those stipulated in Articles 12 and 13. Consuls, vice consuls, or consular agents having Article 3, Article 3, consuls, vice consuls, or consular agents having charge of a post and residing within the territory of the Sultan of Morocco shall be allowed to select but one interpreter, one soldier, and 2 servants from among the subjects of the Sultan, unless they may require a native secretary. These protected persons shall in like manner be subject to no impost or tax, whatever, other than those stipulated in Articles 12 and 13. So they're just giving away subjects, right? For, to work as soldiers, servants, interpreters, employees. Article 4. This is why they're saying that the treaties have given them authority over Moors and stuff like that. They're using treaty and using the treaty to govern us. That's, you know. So can we say they're being criminal? Well, and internationally, from an international perspective, using treaties and stuff, no, you can't really say that. But internally, okay. Domestically, that might be a different story. Article 4, it's about perspective. Article 4, if a representative shall appoint a subject of the Sultan to the office of consular agent in a town on the coast, such agent shall be respected and honored, as shall the members of his family occupying the same dwelling with him. And they, like him, shall be subject to no duty, impost, or tax, whatever, other than those stipulated in Articles 12 and 13. But he shall not have the right to protect any subject of the Sultan other than the members of his own family. So he can extend his protection to any subjects of the Sultan. And by the way, this article right here tells you where the Vienna Convention on diplomatic relations get their idea from. This is or should I say, the Vienna Convention on diplomatic immunities. That's what I meant to say. These are diplomatic immunities that are being afforded to these people. That stipulate, as it says, other than those stipulated in Article 12 and 13, right? But the family is extended to their families, their children, right? No duties, impost, or tax. Article 5. Let's finish Article 4. He may, however, for the exercise of his functions, have a protected soldier. So he can have a protected soldier. Officers in acting charge of vice consulates, being subjects of the Sultan, shall, during the exercise of their function, enjoy the same rights as consular agents who are subjects of the Sultan. All right, Article 5, the government of Morocco recognizes the right of ministers chargés d'affaires. So you see where you get the term chargé d'affaires? When they say that our treaties are the most powerful, it just is. And it's funny because it trickles down on all levels. Everything that we do, we just, whether it's international law, treaties, or it's hip hop, everybody just do what we do. We are the example of the world. We are the example of the world. That's why the world can't wait for us to come back into power. They're looking for us to come back into power. Where are the Moors? The mighty, mighty Moors. Everybody do what we do. There is no New York in Nigeria, and it's easy to find like pictures or videos of Nigerians with Yankee caps twisted to the back. Everybody want to be us. That's why they say that, like that saying goes, they all want to be like us, but no one wants the experience. Well, they're going to want the experience real soon. Because the experience that we're talking about coming with is decolonization, taking over the system, taking over the industries. They all do as we do. And so that's what you're seeing here with this treaty, with these treaties. Chargé d'affaires. So they operate on that title. So why would we not operate on our titles? Like maxims, right? Sharifian authorities. Why not? Sharifian empire, Sharifian jurisdiction, Moroccan governments, Moorish governments. That's what's in all these treaties. The government of Morocco recognizes the right of ministers, chargés d'affaires, and other representatives, which is granted to them by treaties to select the persons whom they employ either in their own service or that of their governments, unless such persons shall be sheikhs, right, or other employees of the government of Morocco, such as soldiers of the line or of the cavalry, in addition to the Maximians in command of their guard. So now we got a Magasnias, magazines. Gotta look that up. In command of their guard. In like manner, they shall not be permitted to employ any subject of Morocco who is under prosecution. Talking about Moors, Black people, subjects of Morocco are Moors, Black peoples, whatever you want to call yourself. All the melanated Asiatic people, those are the subjects of Morocco. If you're a native of Morocco, because you got Nigerians here that look like us, but they're in Morocco, even if in Africa, but this is Al-Maghrib al-Aqsa. We're talking about Al-Maghrib al-Aqsa, Morocco of the farthest west. It is understood that civil suits commenced before protection shall be terminated before the courts which have instituted such proceedings. The execution of the sentence shall suffer no hindrance. Nevertheless, the local authorities of Morocco shall take care to communicate without delay the sentence pronounced to the legation. What legation? Example, the American legation. Where was that at? Where did we see it at? Right here, wasn't it? No, this is where we saw it, right here. American legation. Tangier, August 3rd, 1906. The American legation. That's what they're talking about, right? It is understood the civil suits, down at the bottom. The sentence pronounced to the legation, consulate or consular agency upon which the protected person is dependent. As to those persons formerly protected, who may have a suit which was commenced before protection was withdrawn from them, their case shall be tried by the court before which it was brought. The right of protection shall not be exercised towards persons under prosecution for an offense or crime before they have been tried by the authorities of the country or before their sentence, if any has been pronounced, has been executed. This is where they get their due process from. That's called due process. To learn some things from these treaties. That's why they study treaties, but not publicly like that. And they sure as hell don't want the more studying. They don't even highlight treaties on nothing. They don't want their NBCs or their little white trash people to learn nothing about none of this. Everybody is in darkness. So there's but a few, and many of whom have taken the oath to not death oaths to not reveal these secrets. This is the secret. That's why it's always been a secret. So all the other conspiracy theory things that were secrets, the handshakes and all that. So how come it's like, if it's out here, then it's not a secret. This was kept under wraps. Even though it's been up under your nose the whole time, because it's just public law and it's free, by the way. You don't have to buy, it's not a book that you buy. Sister Pershine, you got a question?
Islam. In Article 5, you said it's a due process. Could we go over the steps of due process? Article 5. Okay, I understand that what subjects are. I understand we're in of Morocco when you're talking about subjects. Okay, I'm trying to get with the due process. Maybe it's in the second paragraph when it says it is understood.
Well, due process means you don't just take someone to jail or lock them up for life without going through the process of performing a proper investigation things of that nature. That's due process of law, right? So in here it says it is understood that civil suits commenced before protection shall be terminated before the courts which have instituted such proceedings. The execution of the sentence shall suffer no hindrance. Nevertheless, the local authorities in Morocco shall take care to communicate without delay the sentence pronounced to the legation, consulate, or consular agency upon which the protected person is dependent. As to those persons formerly protected who may have a suit which was commenced before protection was withdrawn from them, their case shall be tried by the court before which it was brought. The right of protection shall not be exercised towards persons under prosecution for an offense or crime before they have been tried by the authorities of the country. So they have to be tried by the authorities of the country, right? Before they could, it says the right of protection should not be, so that now the right of protection that they receive from this particular treaty can now apply to them. So they first have to be found either innocent or they got to be found innocent, obviously. So it says the prosecution for an offense or crime before they have been tried by the authorities of the country or before their sentence, if any, has been pronounced, has been executed. So what you're really seeing here, as far as I'm concerned, as far as what I'm hearing, is that, you know, you don't just, like I said, you don't just grab somebody off the street and lock them up. You have to take them through the due process of law. And due process of law means mediation, arbitration, adjudication, depending on the offense, depending on what it is. But arbitration usually deals with your investigation, the proper investigation that must take place to identify if the person is actually innocent or guilty. The way the United States operate, they, you know, we know that they're de facto, yet and still, you know, like the term innocent until proven guilty, you know, Black people feel that we're guilty until proven innocent. You know, in other words, if you're guilty until proven innocent, then you're not being afforded the rights of due process of law. Due process of law means that you were found, that you are innocent until you're found guilty. So if you're coming in there being guilty off top without any investigation, then your rights to due process of law are being violated, and that's against the law.
Okay, offense, I get that. A crime, crime is when you harm or hurt an individual, like kill is the number one crime, or that's the crime.
A crime is when the real crime is when they trespass against your person or your property. It's a bigger crime for me to put my finger all in your face, like really touch your face, like just pointing at your forehead or something, than to sell marijuana, right? There's no injured party there. Me putting my finger all in your face like that, that's an injury. You would be considered an injured party. It doesn't matter if it wasn't nothing too drastic like a knife. I still trespass against your person, right? I burn down your house, that's a crime. Break into your house, that's a crime. I steal your car, that's a crime. Trespassing against you as a human being, but they have made commerce a crime to a degree, depending on what the product is that's being sold. So if you sell marijuana, that's commerce. That's not a crime. You didn't trespass against anyone. If you do I don't know, 10 miles over the speeding limit, right? There's no, you didn't hit no one. There's no, you know, you're just getting pulled over because you were speeding. There's no injured party there. That's not a crime, but they treat it as a crime. Huh?
Islam.
Yeah, they treat it as a crime. So a real crime is when you're when someone, that's the difference in common law versus color of law. They practice color of law. And Moors have been trying to force them into the whole common law thing, but you can't exercise your no muscle having behind on people on big muscle on these big muscle boys. You ain't got no muscle to flex. What is the muscle that you're flexing, that you should be flexing? Consular court. You ain't got consular court, you ain't, man, sit down somewhere. You might as well just be a Negro. and just operate from that perspective as a citizen. And you can get remedies that way. When you become a Moorish American, you lose all your remedies. You have nothing. You just a stateless person standing your square, making your way through life. That's not the way to do things. That never made sense to me. So try, where's my nationality card? I got an RV publication nationality card, but that's gonna get off the subject. I wanna get back and finish up this. Let me, is there any other questions, sister, that answer your question?
Islam.
All right, Islam. And anyone that has a question, I'm not gonna be able to see your hand. I just happen to see hers because she happens to be on this little bar for the Zoom bar. So if you have a question or comment, just come on in because I can't see the whole panel or the whole room. And Sister Parashine, if you don't have another question, would you mind taking down the hand? Because it's gonna make me feel like you got a question. All right, Article 6. Protection shall extend to the family of the person protected. His dwelling shall be respected. It is understood that the family is to consist only of the wife, the children, and the minor relatives dwelling under the same roof. Protection shall not be hereditary. A single exception, which was established by the Convention of 1863, but which is not to create a president, shall be maintained in favor of the Benjamin family. Nevertheless, if the Sultan of Morocco shall grant another exception, each of the contracting powers shall be entitled to claim a similar concession. Article 7. Foreign representatives. So now Article 7 is what we use in our documents. We invoke Article 7 because it's dealing with the list of protected persons. Foreign representatives, and in that document, the 1913 Protectorate document, where the minister, the Secretary of State, and the French ambassador were going back and forth. That's also what they were talking about, the list in Article 7 and Article 8. Foreign representatives shall inform the Sultan's Minister of Foreign Affairs in writing of any selections of an employee made by them. They shall furnish annually to the said minister a list of the names of the persons protected by them or by their agents throughout the states of the Sultan of Morocco. Throughout the states of the Sultans of Morocco. All those states belong to the Sultan of Morocco. And if the Sultan of Morocco is no longer the Sultan of Morocco and the Moorish states are the successors of the Sultan of Morocco, that means then that all those states belong to the Moorish states. We got a lot of power, Moors. We got a lot of power. Throughout the states of the Sultan of Morocco. This list shall be transmitted to the local authorities who shall consider as persons enjoying protection only those whose names were contained therein. Article 8, consular officers shall transmit each year to the authorities of the district in which they reside a list bearing their seal of the persons protected by them. These authorities shall transmit it to the Minister of Foreign Affairs to the end that if it be not comfortable to the regulations, the representatives at Tangier may be informed of the fact. A consular officer shall be required to give immediate information of any changes that may have taken place among the persons protected by his consulate. So they have to provide a list, right? That list immediately of any changes that has taken place. So what I was telling you all in the other class, we'll be sending them a list of our protected nationals. Remember I was saying that we would, in due time, we will be requesting a list back from them because that their list will change. So we need that update. What is that update? That our nationals that are protected under our state that were on that list, your list got to be updated to show and prove that those same nationals are no longer on your Negro list. if you will, as citizens, subjects, whatever. So they have to send us an updated list with those names saying that they're, or confirming that they are AMPAG, Moroccan nationals. That's what that deals with. That's what I was talking about on the last call, on the last class, right? Because the list would have changed. If we send you a list of the former Moroccan subjects as now being nationals protected under our flag and seal, then you have to send us, so that means your list would change. It would need to be updated, because those people that you once upon a time had on your list as Negroes, they're no longer that. They're no longer Moorish subjects. So you have to send us a list that shows that the change in status of those people. Article 9, servants, farmers, and other native employees of native secretaries and interpreters shall not enjoy protection. So the servants, farmers, right? Who are the farmers, right? When you see that word farmers, what would you think, considering the time frame? Slaves, right? Like when you look at the slave movies and stuff, they'll have the so-called Africans out there as farmers. Those were Moroccans. And that necessarily didn't happen, or at least not to that degree. In many cases, those same people working on those farms were their own farms. It's no different than me riding by, your house, and you're out there cutting the yard, and I take a picture of it and I see, look, a black slave cutting my yard, right? That's what they were doing. But anyhow, obviously according to the treaty, the subjugated Moors were working as servants and farmers, right? So it says servants, farmers, and other native employees of native secretaries and interpreters, also working as interpreters, because they didn't know our languages, right? Can we work as interpreters today? No. We don't know those languages no more. We need to be interpreted for. You see how far we fell in just 200 years, which is enough time to really subjugate a people and take them out of their proper status, turn them into 3/5 of human beings, right? Shall not enjoy protection. The same shall be the case with Moorish employees or servants of foreign subjects. Nevertheless, the local authorities shall not arrest an employee or servant of a native officer in the service of a legation or consulate. So they were in the service of, like, for example, the American legation or consulate, or of a foreign subject or protected person without having notified the authority upon which he is dependent. If a subject of Morocco, here we go again, in the service of a foreign subject shall kill or wound any person or violate his domicile, he shall be arrested immediately, but the diplomatic or consular authority under which he is shall be notified without delay. Dred Scott, Article 20 of the Treaty of Peace and Friendship. If a subject of Morocco in the service of a foreign subject shall kill or wound any person or violate his domicile, he shall be arrested immediately. But the diplomatic or consular authority under which he is shall be notified without delay. Because anything dealing with a subject of Morocco goes through consular court. Doesn't matter what it is. That's why Dred Scott was found as a plaintiff in error, because he petitioned the wrong court. He was supposed to petition consular court, because his proper status is that of a subject. So now, since your status is now Negro, black, colored, citizen, really, your legal personality, your legal status is that of a citizen. It was changed from subject to citizen. Now, as a citizen, you can petition the Supreme Court, and as a Negro, you can operate. But as a subject, you would have needed consular court. And that understanding would have brought us much closer to winning this fight. So when they took us out of that understanding, it took us far from winning this fight, far away. They took us down through there. They took us all the way down somewhere. I don't know where they took us, everywhere but Morocco. They took us all the way to Egypt. We pharaohs and stuff, you know. They took us far away from Morocco. That's why it took so long. And it's funny that the prophet came at the right time to bring us back to Morocco. If it wasn't for the prophet, we still would be swimming the Atlantic Ocean looking for Africa. He took us away from home so bad mentally, psychologically. It was that's something else right there, man, when you really think about it. So anyhow, so if a subject, anything dealing with a subject of Morocco, anything dealing with a Moor, the proper venue is dealing with the consular court. Consular court. Period. But right now we don't have consular court because we don't have state governments. But in the trust territorial, formerly known as Georgia, there's a consular court. In the trust territory formerly known as Colorado, there's a competent consular court. Same as the trust territory of Oregon, formerly known as Oregon. Article 10. Nothing has changed with regard to the situation of brokers as established by the treaties and by the Convention of 1863, except what is stipulated relative to taxes in the following articles. Article 11, the right to hold property is recognized in Morocco as belonging to all foreigners. The purchase of property must take place with the previous consent of the government. What government? Moroccan governments. So the right to hold property is recognized in Morocco as belonging to all foreigners. The purchase of property must take place with the previous consent of the government. And the title of such property shall be subject to the form prescribed by the laws of the country. What country? Well, and then it says right here, implemented by Article 60 of General Act of Algeciras, 1906. That's all. That's dealing with Article 60 of the Act of Algeciras. The Moorish government, they must get permission from the Moorish government to be able to own property. Any question that may arise concerning the right shall be decided according to the same laws, with the privilege of appeal to the Minister of Foreign Affairs stipulated in the treaties. It's all about the treaties. Article 12, foreigners and protected persons who are the owners or tenants of cultivated lands, as well as brokers engaged in agriculture, shall pay the agricultural tax. And the treaty of the Act of Algeciras is called a tertib. They shall send to their consul annually an exact statement of what they possess, delivering into his hands the amount of the tax. He who shall make a false statement shall be fined double the amount of the tax that he would regularly have been obliged to pay for the property not declared. In case of repeated offense, this fine shall be doubled. The nature, method, date, and apportionment of this tax shall form the subject of a special regulation between the representatives of the powers and the Minister of Foreign Affairs of His Sharifian Majesty. Ashira, you got a question?
Yes.
Okay.
Yes. I was wondering, they wrote this in 1880, but they're referring to the Treaty of Algeciras that was written in 1906. I wouldn't have.
Oh no, that's a sub note from the people that put it together from Calameo. or whoever these people are that put this, what's this website? I forgot the website you get this from. But that's a sub note letting you know, see, is implemented by Article 60. So what it's saying is that Article 60 implemented Article 11 from the Act of Algiers, from the Treaty of Madrid. So this is occurring, I don't know when they put this here, but this is after the act. This is like, you know, this wasn't done by the treaty, the people that, by the Sultan and the people that put the treaty together. This is authors, not an author, what do you want to say, a publisher's note.
Oh, I thought you had read it in the thing. That's why I was wondering.
No, that's not part of the treaty. No, that's not, that's a publisher's note, sub note. No, the treaty, that's not part of the treaty. That's why you see that line right there, dividing it. You see that line?
Yeah.
Mhm. That's a publisher sub note or whatever. Whatever you call that. I'm not even sure if I'm saying it right when I say a publisher's note, but it's more accurate to say than you would say that it's part of the treaty, because it's not. I lost my train of thought. Okay. So it says the nature, method, date, and an apportionment of this tax shall form the subject of a special regulation between the representatives of the powers and the Minister of Foreign Affairs of His Sharifian Majesty. So the representatives of the foreign powers and the Minister of Foreign Affairs of the Moroccan government there's the special regulation. So it says of a special regulation between the representatives. So they have to determine between the two the nature, method, date, and apportionment of the tax that's being charged. What's the taxes that's being charged? He who shall make a false statement shall be fined double the amount of the tax, and he will regularly that he would regularly have been obliged to pay for the property not declared. In case of repeated offense, his fine shall be doubled, and the nature, method, date, and apportionment of this tax shall form the subject of a special regulation between the representatives of the powers and the government of the Sharifian, of His Sharifian Majesty. Right? So they're working together on that matter. I read in Wikipedia, and I know you don't just, I know, but I read that it was saying that the Madrid Convention was because, see, these signatory powers had conquered Morocco in many different pieces. And this treaty was put together to confirm the conquest and recognize the conquest by the Sultan, even though they gave us the out in Article 15, right? And I'm wondering, and I was thinking to myself, well, that sounds about right, because as you read it, you see that it's giving them the authority over subjects of Morocco in various degrees, right? Not 100%, not full powers, but I guess enough to enslave us. Yet with an out from it based on Article 15. But then you consider also that at that time, the seat of the Sultan was already conquered, right? Because at that point, or in that time, you were dealing with the pale Arabs sitting on that seat. So I say all that to say that to me, it seems like one big conspiracy that took place with Morocco, the empire, the Sultan, and all these European powers. Just a thought. Article 13, foreigners, protected persons, and brokers owning beasts of burden shall pay what is called the gate tax. The apportionment and the manner of collecting this tax, which is paid alike by foreigners and natives, right? So this tax is paid also by natives. Shall likewise from the subject of a special regulation, form the subject of a special regulation between the representatives of the powers and the Minister of Foreign Affairs of His Sharifian Majesty. The said tax shall not be increased without a new agreement with new representatives, new agreement with the representatives of the powers. My eyes is going crazy. The mediation of, in Article 14, the mediation of interpreters, natives, secretaries, or soldiers of the different legations. Those legations are 12 other legations, American legation being one of them, or consulates, when persons are concerned who are not under the protection of the legation or consulate shall be permitted only when they are the bearers of a document signed by the head of a mission or by the consular authority. These right here are some more subnotes. Footnotes. Footnotes is the word. Yeah. I don't know why I said subnotes. Footnotes. Regulations and execution of Article 12 were signed at Tangier, March 30th, 1881. Great Britain Command Papers, 1882. Okay. The word "not" was omitted in the translation of the convention as it was printed in 22 Stat 823. A memorandum in the files of the Department of State dated April 28, 1883 takes note of the error in the English translation and directs that the correction be made in the pamphlet copy of the convention. So the word "not" was omitted in the translation. That's another footnote. But there's a more powerful subnote. We'll be getting to that footnote. We'll be getting to that footnote. That footnote deals with this right here, Article 15. Any subject of Morocco who has been naturalized in a foreign country and who shall return to Morocco shall have to remain for a length of time equal to that which shall have been regularly necessary for him to obtain such naturalization, choose between entire submission of the laws of the empire and the obligation to quit Morocco, unless it shall be proved that his naturalization in a foreign country was obtained with the consent of the government of Morocco. I already ran over that just a minute ago with what's his name, Hoffman Philip. 1, 2, 3, 4, 5. See, if you see Morocco 5 times in paragraph 1 and paragraph 2. So what happens if you don't choose between entire submission? Foreign naturalization heretofore acquired by subjects of Morocco, according to the rules established by the laws of each country, shall be continued to them as regards all its effects without any restrictions. That's what happens if you don't return back home, Dorothy. You want to stay in the cares of the world? That's what's going to happen to you. So then what they do? Let's go to the straight to the footnote. Right here. So you really want to know what their pain point is? They went the extra mile. They tried it. They tried it. They didn't want you to know this. They didn't want you to wake up to this. They didn't want you to exercise these powers. Because exercising these powers means that they would have to fall back under your authority and pay taxes. And they don't want to be under your authority, and they don't want to pay taxes. So they went as far as they could to get you away from this. By giving you all these names, showing your fake story on TV and in books, in film, etc. A U.S. note of March 7th, 1959, addressed to the Moroccan Ministry of Foreign Affairs, referred to a note from the ministry dated October 8, 1958, in which the embassy had been informed that the Moroccan government had decided to strike all prescriptions relating to Moroccan nationality. Moroccan nationality. Strike all prescriptions relating to Moroccan nationality from the text of the Madrid Convention. The US note said, in part, the government of the United States of America, having unilaterally relinquished certain rights in Morocco with the reemergence of Morocco into independence in 1956. What are we talking about? The Kingdom of Morocco in Africa, Alkebulan, considers that in line with historical developments, Article 15 of the Madrid Convention on Protection of 1880 has become obsolete and without effect. Now, why would you even say something like that? That treaty provision, Article 15, is obsolete and without effect. And why you choose that one out of all the rest of them? Because it deals with Moroccan nationality. That really was trying to bury us and take away our Moroccan nationality forever, or any other, or any way of reclaiming our nationality. They want you to think that proclaiming your nationality is going to RB Bay Publication or the Temple or some group, some organization. Somebody got something to say? It says, then it goes on to say, the government of the United States takes due cognizance, therefore, of the action taken by the Moroccan government as set forth in its above cited note, which the United States government understands to refer only to Article 15 of the Madrid Convention on Protection of 1880. They tried it, but it didn't work. For one, the king of Morocco is no longer the Sultan of Morocco. So the king can't strike the record. It would have had to been the Sultan. It would have had to been from the seat of the Sultan. But it had already been vacated. So between the pale Arab king of Morocco in Africa and the United States of America, they tried to get Article 15 removed and considered obsolete and without effect, so that we no longer could have the possibility or even the opportunity to return back to Morocco and declare our nationality the right way, the competent way, through your state government, not through no temple. I respect all this, right? Prophecies, the oral prophecies and statements. I respect all these documents, all this literature. This is the prophet's literature, all this right here. Quran so old, it done tore up on me, right? I respect all that. That's not going to give me my nationality. You don't proclaim your nationality through a temple. What it gave me was the first half, which is the divine side of my birthright, right? The divine understanding of who I am as a Moor and who we are as a Moor. But that doesn't give me my nationality. This tells you how you get your nationality. It's through Article 15. If it wasn't so, and they weren't so concerned about it, and it didn't mean nothing, then they wouldn't go as far as to try to strike it from the record, saying that Moroccan nationality is without effect and obsolete. They scared of us and our proper person. What is our proper person? Moroccan, period. We're not Americans. They love hearing you say, you American. That's a trick bag. I've proven it over and over. The American legation was for the Americans, not the Moroccans. The Moroccans are the American legation exists in Morocco. We have consular court. That's what we have, and that's what we're supposed to exercise. They didn't want us to know that we were subjects. They didn't want us to know that we were Moorish subjects or Moroccan subjects. Negro, blacks, colored, Afro-American, they gave us a hairstyle, Afro-American. Article 16, no irregular or unofficial protection shall be granted in future. The authorities of Morocco will recognize no protection of any kind whatever, save such as is expressly provided for in this convention. Nevertheless, the exercise of the customary right of protection shall be reserved for those cases only in which it may be desired to reward signal services rendered by a native of Morocco to a foreign power or for other altogether exceptional reasons. The Minister of Foreign Affairs at Tangier shall be previously informed of the nature of the services and notified of the intention to reward them in order that he may, if need be, present his observations thereon, yet the final decision shall be reserved for the government to which the service shall have been rendered. The number of persons thus protected shall not exceed 12 for each power, and this number is fixed as the maximum unless the consent of the Sultan shall be obtained. So the Sultan still had the power to, even though he was giving up all the power, or I ain't gonna say giving up his power, but giving up much of the land. The status of persons who have obtained protection in virtue of the custom, which is henceforth to be regulated by this stipulation, shall be without limitation of the number of persons belonging to this class, and now so protected, the same for themselves and their families as that which is established for other protected persons, right? And then we've already went over this footnote. Fascinating. They tried to say that Article 15 is obsolete and without effect. Shame on you, it didn't work. Article 17, the right to the treatment of the most favored nation is recognized. Where did we learn that from? Where did we discuss that? Where did we remember hearing that? The case between France and the United States, the most favored nation clauses. The right to the treatment of the most, and that's why they were invoking treaty provisions from the Treaty of Madrid. France was against the United States, and the United States was doing the same thing against France. They were battling back and forth using the Treaty of Madrid and the Act of Algeciras and the Treaty of Peace. That's why it says the right to the treatment of the most favored nation is recognized by Morocco as belonging to all the powers represented at the Madrid Conference. France was there represented, and so was the United States. That's why they were battling back and forth, talking about the most favored nation, the most favored nation clause and all this stuff. Using our treaties. While we were marching, praying, and integrating. Trying to get to that white man's water fountain. You want to use his water fountain too. Trying to get in the front of the bus. We out here trying to get in the front of the bus and drink from their water fountain. This is, come on. You see why we were viewed and treated as minors? It's time to get to the higher stage, mothers and sons, brothers and sisters. It's time to get to international law. That's the highest stage. That's where you now become an adult. That's where you now have to pull your big boy pants up and deal in politics. And you do that, you'll defeat the colonizers every time. They can't deal with you with that pen. This is our power right here, the pen. This is your scimitar. This is your sword. This is your AR-15. This is your Draco. This right here. That's your Glock. That's your 380. Article 18. Now here are the directions, the instructions. All treaties got the instructions. So this is 1880. This is not 2022 or 1945, between 1945 and 2022. As of 1945, up until now, which is 2022, the depository is the United Nations. This is 1880. Let's find out where you deposit international documents. This convention shall be ratified. The ratification shall be exchanged at Tangier with as little delay as possible. So it's Tangier. By exceptional consent of the high contracting parties, the stipulations of this convention shall take effect on the day of which it is signed at Madrid. In faith whereof, the respective plenipotentiaries have signed this convention and have thereunto affixed the seals of their arms, done at Madrid in 13 originals, this 3rd day of July, 1880. So the depository was Tangier. So they had to ratify it. And here they use the word exchanged at Tangier. And who are the parties? So the first page was showing you all their names of the signatory power of their plenipotentiaries, ambassadors, etc. Here they just give you the names of the states with one name. So the United States, the first one off top. And they were being represented by Lucius Fairchild. Germany, E. de Solms. Austria, Hungary, Ludolf. Belgium, Anspach. Spain, Canovas del Castillo. France, Jaurès, or whoever. United Kingdom, L.S. Sackville West. Italy, J. Greppi. Morocco, Mohammed Vargas. Signature in Arabic. For the Netherlands, Helderwire. Portugal, Cassar Ribeiro. Sweden and Norway, Ackerman. Those are the signatory powers. Those are the states that colonized Morocco. But we have authority over those states. That's the conclusion of the Treaty of Madrid. Are there any questions, statements, concerns?
Peace, brother. Do
Peace, good brother. Peace, peace.
peace and love, everybody. I will just make a statement. Those signatories that you just showed at the end is proof that the footnote to Article 15 was nothing but the puffy remix. It's like you were saying earlier. The NBCs that read that footnote would think that the United States had all the power to change everything, but they weren't the only signatory to this multilateral treaty. So in order to change anything, they would have had to have the other signatures to the treaty. And basically, they did what they did, and there were those who will see that and think there's no remedy and move forward. But we know that when you're talking to international law, one country that acceded to a treaty doesn't change anything by itself.
Correct.
I yield.
It's all good, brother. Thanks for that comment. But you see but that shows you the pain point that the United States is dealing with. The Moroccan nationality and consular court has been a thorn in their behind for the past 200 years, and it's getting bloodier and bloodier the closer we get to the later years of the of this new millennium or millennia of the 2000s.
Ashe.
You know,
Ashe.
it's getting bloodier and bloodier. Right now, they're in trouble right now, as a matter of fact. Adam Moore tell me that they're in receivership. Yeah, they are in receivership. They've been in receivership. To who? Moroccan governments. Period. Not the Pope. The Pope ain't got no authority over the United States like we do. We got the authority over the United States because they exist and operate on our land. This ain't Italy, and this ain't the Vatican. This is Morocco. And the United States is in Morocco. We've been a thorn in their behind for the longest, but only as Moroccans, right? So when the prophet came, demonstrating the Moroccan nationality and customs and culture, you know, divine creed and all, to put them in a bad state, like, oh Lord, we got the treaty, all these treaties in the background, and we got this dude internally, domestically. That's why, you know, he was dangerous for them. But at the same time, they also knew that it was so many of us that was subjugated that it would have been a tough task for the prophet. That's why, who was it? One of you all could probably help me. Who told the prophet that, which one of the presidents told the prophet that putting his Islam and those niggers is like putting a pants on a horse? One of those presidents said that to the prophet. You know,
That would be Woodrow Wilson.
Woodrow Wilson. That's who it was. Woodrow Wilson, 1912 or something like that. This is that, but we're back to that document. We're going to finish up that document, the correspondence between France and the Secretary of State. And I just wanted to point out the word Muslim, Muslim subject, Muslim subjects. So it's Moroccan subjects, Muslim subjects, Moorish subjects, and proteges. So where we left off was exchange right here, number 1315. The Secretary of State to the French ambassador. It was April 30th, 1914. So these correspondences began in 1913. So then here comes the United States, Secretary of State to the French. Excellency, I have the honor to inform your excellency that the department is in receipt of a telegram from the American Chargé d'Affaires at Tangier, stating that the French diplomatic agent in that city, in the name of the French resident general, had requested of him a memorandum of pending and unsettled claims, understanding that this government would not be favorably inclined to recognize the French protectorate until those cases were satisfactorily disposed of. Like, you can't, the United States got to, it said that they're not going to recognize the French protectorate. You ain't got no choice but to recognize the French protectorate. This signed, sealed, and delivered, fool. United States, sometimes. The American legation, there you go. There you go. The American legation at Tangier. So they had a legation in Tangier, which is similar to an embassy. An embassy is operated by an ambassador. A legation is operated by a minister. The ambassador is a higher rank than that of a minister. But they required an American legation because that's how it is. You know, all states have embassies or legations in other foreign states, right? For the interface of their nationals, etc., and other diplomatic or political operations. So the American legation is at Tangier in Morocco. Moroccans we don't need an American, we never had an American legation because we're not American. That's the point that I'm really trying to make. We're not American. They are the Americans. Therefore, they needed an American legation at Tangier. And it has been instructed to submit to the proper French, to the proper French protectorate until those cases were satisfactorily disposed of. I'm sorry, I lost my train of mind. I dropped this cup and the American legation at Tangier has been instructed to submit to the proper French authorities a memorandum of all pending American claims in Morocco. And I beg to assure your excellency that a satisfactory solution of these cases would greatly aid this government in replying to your note of January 8th, 1913, containing the request of our government for the formal recognition of the French protectorate in Morocco. Right? That was that adhesion, adhesion to these, something like that is what the French said. They was asking for an adhesion or a signature. The French ambassador to the Secretary of State, June 10th, 1914. Mr. Secretary of State, my government, to which I did not fail to forward the contents of your excellency's note of February 13 and April 30th last about the doing away with extraterritorial rights in the French zone of Morocco and about certain claims of American citizens, has just affirmed to me that it had promptly taken steps to bring about, under the most equitable conditions, a settlement of those claims. In regard to one of them, that of the vacuum oil company, my government, which had never heard of it, wrote to Morocco to inquire about the grievances the concern might have to state as to customs treatment it receives. General Lottie accordingly called upon the agent of the company for explanations. The answer was that he had not the slightest ground for complaint against the customs authorities. As for the other claims, the instructions sent by your excellency to the representative of the United States at Tangier have no doubt brought to your knowledge with all the needful explanations, the facts from which those claims may have arisen. I beg leave in this connection to refer to the note I had the honor to address to your excellency on the 22nd ultimo April, in which, while answering the main points mentioned in your note of February 13th, I laid stress on the importance attached by the government to the government of the United States, earliest possible accession to the request I had laid before you. I am informed by my government that Russia, Spain, and Norway have already renounced their extraterritorial rights by signing a declaration like that enclosed in my above mentioned note. Other accessions are momentarily expected. What about you, United States? So they're trying to get the United States to sign the agreement renouncing extraterritorial rights in the French zone of Morocco, letting them know that Russia, Spain, and Norway already have done it. And we're waiting on the rest of the signatory powers to sign it as well. What about you, United States? And that's what the United States don't really want to sign, talking about they don't want to recognize it. Right? They don't want to lose their authority and control over these Moors. Hold up, let me see. Okay, all right. And then here, the French chargé d'affaires to the Secretary of State. So here comes France again. So France came once and then they come in again, in case you didn't get us the first time. This one was in June 10th, 1914, and this next one was in July 16th, 1914, a month later. Mr. Secretary of State, in the course of the negotiations for the suppression of consular courts and the extinction of extraterritorial rights in the French zone of the Sharifian Empire, it was occasionally objected to the representative of the Republic that it was not possible for the powers to take any further responsibility in the fate of their Moorish protégés, right? It was occasionally objected to the representative of the Republic that it was not possible for the powers to take any further responsibility in the fate of their Moorish subjects or proteges. There would seem to be some foundation for that feeling. In fact, under the provisions of Article 12 of the Franco-Germany Agreement of November 4th, 1911, whose full scope is given in the explanatory letter, the government of the Republic would certainly have the right, after the discontinuance of the consular courts, to ask that protection be done away with. The strict legal effect of this would be to place under native jurisdiction the proteges who under the present system are enjoying consular jurisdiction, but with the view to obtaining or obviating the hardships that might thereby be brought upon the Moorish subjects. I mean, I hope that y'all heard me and are listening and paying attention to the things that I'm saying. I need y'all to pay attention to the words that are coming out of my mouth. But with a view to obviating the hardships that might thereby be brought upon the Moorish subjects, thus deprived of protection, the government of the Republic is ready to declare them to be, as long as they live, under the jurisdiction of the French courts set up in the Protectorate. So they're trying to punk the United States out of the, it happened again. So they're trying to punk the United States out of the control of the Moors and the protection of the Moors. Everybody want to protect the Moors. Why? Because the Moors are the trust fund babies. Don't want a piece of that. My government authorizes me to make its intentions as to this known to the federal government, being convinced that they are likely to remove any apprehension concerning its proteges, if after availing itself to the rights conferred upon it by the existing provisions, the government of the Republic should procure the abolition. Yeah, abolition. I avail myself of this opportunity to enclose 3 copies of Louis Renault's preface to the codes and laws in force in the French Protectorate in Morocco, which brings forth the value and importance of the legislative work of the Protectorate, showing as it does the guarantees extended to all foreigners in Morocco. That paper ought to expedite adhesions to the new system on the part of the few powers that have not yet relinquished the exercise of consular jurisdiction. Be pleased. R. Klaus. So here comes France again. Same date. July 16, 1914. So they must have sent out 2 letters. They ain't playing with the United States, I guess, huh? Mr. Secretary of State, by a letter dated February 13th last, Mr. Bassett Moore made known to the embassy the federal government's intention in respecting the acceptance of the jurisdiction of the new courts instituted by us in Morocco for persons subject to American jurisdiction. At the time, Mr. Bassett Moore expressed a strong desire to arrive at settlement of various questions affecting American interest in the Sharifian Empire, right? The questions affecting American interest in the Sharifian Empire. The resident Commissioner General of the French Republic, to whom the State Department's note was forwarded by the Minister of Foreign Affairs, has returned to Mr. Viviani an answer, the substance of which I have the honor to communicate to you, with the exception of 2 clearly defined cases, Vacuum Oil Company and the Benetuil case, which will be fully explained hereinafter. The federal government formulates, but does not specify, reservations or demands of a purely general character against the Protectorate government. There is no question about the federal government being as much as any other warranted in watching over the economic rights and interest of Morocco. There is no question about the federal government. What federal government? The United States. There is no question about the federal government being, as much as any other, warranted in watching over the economic rights and interest of Morocco, which, as put by Mr. Bassett Moore, are safeguarded by the treaties concluded between the foreign powers and the Sharifian Empire. But it is equally true that the Protectorate government is bent on respecting to the fullest extent in favor of Americans. You see how you see the Sharifian Empire, Americans, two different people. You're not Americans, Moors. On no level, not even a little bit. It's actually fraud for you to claim American. That's identity theft. You're not American. But it is equally true that the Protectorate government is bent on respecting to the fullest extent in favor of Americans as well as all other foreign citizens or subjects the principle of economic equality, sovereignty and independence, integrity of domains, economic liberty without any inequality, i.e. economic equality. The principle being once more evoked. The reservations or claims put forth by the federal government are so general in their character that from the fact that the importance of American interests, not Moroccan interests, not Moorish American interests, American interest, and the number of persons lying under American jurisdiction appear to be out of proportion to the set of reservations and objections offered. The question arises whether Mr. Bassett Moore's letter of February 13, 1914 is not aiming after all, and while the federal government expressed itself in favor of the reforms, to reopen the question of the very principle of the Protectorate regulation powers. As a matter of fact, it does not seem possible to maintain the protests that have been made against the Protectorate government upon careful examination of every one of the questions presented. One, as regards the contemplated martial law in cases of contraband of arms, the matter having been settled by dropping the subject need not be brought up anew. Two, the federal government's statement about protection leads one to believe that the meaning and scope of the Protectorate's intentions have been misunderstood. Indeed, it never was therefore our intention to do away with protection, but we meant merely to stop its improper use through a revision of the list jointly with a delegate of every legation concerned. Provision, furthermore, for such a revision was made in the Franco-German treaty to which the government of the United States gave its adhesion. It is important, however, is adhesion meaning that they signed that treaty, right? Or acceded to that treaty. It is important, however, to take notice of Mr. Bassett Moore's assertion that the choice of the American proteges rests ultimately with the government of the United States. For the right to choose can only be exercised within the limits wherein it conforms to the treaties of the provisions of which the Moxon may remind the powers concerned in order to obtain a return to the enforcement of those conventions. If the powers would forego in principle their consular jurisdiction, we might per contra take up such an enforcement in as liberal as a spirit as possible, and to that end, come back to a bilateral revision as provided in the Franco-German Treaty. 3, the remarks offered in regard to the original circular of November 1st, 1912, laying down rules for the purchase of land appear to have been prompted by an incomplete study of the subject on the part of the Washington government. On the one hand, the consent of the government referred to in Article 11 of the Madrid Convention and Article 60 of the Act of Algeciras, and again mentioned in the regulations of November 1st, 1912, does not, of course, apply to any but those parts where such consent is requisite, is requisite, that is to say, without the 10 kilometers zone around the ports and the 2 kilometer zone allotted to Azimur. On the other hand, the circular of November 1st, 1912 cannot apply to the Tangier territory specifically referred to in the American memorandum, since Tangier and its purlieus do not come under the regulations decreed in the Protectorate. As to the Haboos, or government land, the Gish lands, the circular of November 1912 merely repeated in their respect pre-existing principles that are in force in every state. That it is to say, the principle that some land is public domain and inalienable. And again, bringing forward that principle, the resident general merely availed himself of the power to issue regulations granted by the Franco-German Treaty. In answer to the fault found with servitude zones, we are justified in hope. So it says servitude zones. That's a new one. What is a servitude zone? It's like slave zone. What that mean, right? Wow. Okay. In answer to the
concentration camp or something.
Yeah, probably, yeah, something like that. In answer to the fault found with servitude zones, we are justified in holding that all purchases of land are permitted by the Act of Algeciras, Article 60, subject to the obligation placed on the purchaser to conform to the laws and usages of the country. Now, the Sharifian decrees creating zones of military servitude are precisely to be numbered among local laws, as the aforesaid Act of Algeciras could not presume to prevent on every subject but whatsoever laws and usages, or include in that phrase only those that existed in 1906. Mr. Bassett Moore's letter further on asserts that the records of land titles, which must furnish the Cadiz with the means of verifying the validity of the contemplated transactions, are very incomplete. The conclusion drawn by Mr. Moore from this purely gratuitous assertion would, if accepted, have but one result: a perpetuation of wrongs based on those previously committed. Furthermore, when looking into the lawfulness of pending transactions, the local authorities do not confine their investigation to an inspection of the said records. 5. As regards Article 63 of the Act of Algeciras, the Protectorate government never showed any intention to evade its operation, and still more unfounded is the assertion that the Sultan gave notice to the diplomatic corps of measures aimed at the recovery of property of the class referred to in the aforesaid article. Such a notice never was served. The only measures taken for their sole object, the prevention for the future of the wrongs, the settlements of which for the past must be effected in accordance with the procedure directed by the Act of Algeciras. 6. As for the customs grievances formulated by the American government, so you have the American government and you've got the Moroccan government. You got the American government, and then you've got the Sharifian authorities. You've got the United States, and over here, you've got the Moroccan government. Over here, you got the United States of America. Over here, you got Morocco. Like, we're two different entities. Stop it, Moors. We're not Americans. We're not Americans. I'm sorry. We're autonomous. We're Aboriginal, and we are indigenous, no doubt. But that's to Morocco, not America. As for the customs grievances formulated by the American government, the Protectorate government is quite ready to give them full consideration when they are specified. The only case presented in the memorandum of February 13 has been investigated at Casablanca by our consul there. He reports that the agent of the vacuum oil company at Casablanca told him he had not the slightest ground for complaint against the customs authorities. But the memorandum of the Charge d'Affaires of the United States at Tangier, hereinafter discussed, having explained that the difficulties under consideration had occurred at Safi and not at Casablanca. General Loti referred the question to the office of the controller of the debt of Tangier, which will furnish all the data with which the settlement of this customs difficulty may be taken up at the earliest possible date. 7, as regards the American claims against the Moxon, the American claims against the Moxon is not a Moxon American, and it's not an American Moxon. Two different people, two different jurisdictions. As regards the American claims against the Moxon, the government of the United States may be assured that they will be examined in the same light as all the claims of persons under foreign jurisdiction. Those already passed upon by the Commission of 1910 will be paid in toto, T-O-T-O, to the beneficiaries out of the funds of the loan that has just been voted. What is toto? That's an interesting, it's a type of currency. Number 8, as for the Benatul case, our agency at Tangier gives me the following information confirmed by Mr. Philip, our consul at Tangier. It agrees with the information supplied by the Washington government. Jacob Benatulio, an American censor, having obtained a judgment from the Shra about 8 years ago in a real estate suit against several foreigners, of whom one, Mr. Fries, was French, did not choose to apply to our consular court for an executor of the Cadiz judgment. The legations of France, so France has a legation, America has a legation, all the foreigners have a legation. The legations of France in America tried but failed to bring about a friendly settlement of the Cadiz award by a payment by Mr. Fries. So the legation of France and America failed to bring about a friendly settlement of the Cadiz award. So that tells you the power of the Cadiz on the line, you Cadiz out there, right? You guys are involved with all this. AMPAG has 3 Cadiz. Put our fellow citizens arguing that the judgment against him had been obtained by fraud, would not listen to any settlement. Inasmuch, however, as the land in dispute lies within the Tangier zone, the American government cannot condition the relinquishment of its extraterritorial rights upon a settlement of this case, which by reason of its situs does not lie under the jurisdiction of the Protectorate authorities. In order to arrive at a more precise knowledge, if possible, of what is asked of us, our agency at Tangier has been instructed to apply to the Charge d'Affaires of the United States for such information as he possesses about the American claims the government of the United States wish to have settled before recognizing our courts in Morocco. Mr. Blake's memorandum under the date of May 7th, sent in reply to our Charge d'Affaires, comprises 14 claims. But 7 of these may be even now stricken out. The first 5, including the Benatul case, belong in Tangier, and the other 2 in El Khazar and Larak. They therefore do not come by reason of their situs under the jurisdiction of the Protectorate and cannot be brought into a discussion of the relinquishing of extraterritorial rights in the French zone. As to the other 7 claims, they are all routine cases and most of them of a judicial nature. They do not offer either in their character or their importance a class of litigation which may afford ground to the United States for further postponing the relinquishment of its extraterritorial jurisdiction and privileges. The resident general is, at any rate, even now making it his duty to set on foot an examination of those cases and investigations by the Protectorate local authorities respectively concerned therein. But these cases apparently are not such as to warrant opposition as a matter of principle to relinquishing the American extraterritorial rights. American extraterritorial rights. Moors don't have extraterritorial rights. So how can you be an American? It's an American extraterritorial rights. Moors don't have extraterritorial rights. Stop trying to claim these people's identity, while at the same time saying that they're stealing your identity. That is such a ridiculous trick bag. Moors would say that the United States colonizers are stealing their identity as Americans, because of what 1828 Webster's Dictionary say. I don't care what the Webster's Dictionary say. What the treaty say? What these discussions, what are these discussions saying? It said American extraterritorial rights. Since the resident general is even now ready to examine and settle those cases in the most conciliatory manner, I deemed it expedient to relate herein above the explanations furnished by the Commissioner of the Republic, which answer every point in Mr. Bassett Moore's memorandum. These explanations meet every claim and objection of the federal government, both in satisfying inquiries bearing on specific points and in carrying promises as to minor points that could not yet but will be settled. Finally, the report throws as full a light as may be desired on some other topics that do not seem to have been correctly understood or interpreted. The willingness of the federal government to recognize the Protectorate regulation powers cannot be doubted by the embassy or by the French government. I am convinced that your excellency will find in the foregoing explanations all the palliations you may wish for. And I have no doubt that you will, as has already been done by most of the other powers, agree to forego the benefits of extraterritoriality in the French zone of the Sharifian Empire and accept to place persons subject to American jurisdiction under that of our courts. Just read that again. As has already been done by most of the other, let me go back. I am convinced that your excellency will find in the foregoing explanations all the palliations you may wish for, and I have no doubt that you will, as has already been done by most of the other powers, agree to forego the benefit of extraterritoriality in the French zone of the Sharifian Empire and accept to place persons subject to American jurisdiction under that of our courts. The French want American citizens, everybody under the jurisdiction of their courts. Aware of the friendly and reciprocal good will which always preside over the settlement of such questions between our two countries, two states, two countries, not individuals and versus a country. It's always two countries. International law deals with two countries or country relations, I should say. Individuals are not allowed in international law, in the international venue, in the international arena. individuals get put to, they're given a seat to go sit down somewhere. They're not allowed. This is a prestigious club. You have to check the boxes in order to operate in international law. Aware of the friendly and reciprocal, we already read that, right? I'll read it again. Aware of the friendly and reciprocal good will which always preside over the settlement of such questions between our countries. I cannot but remind once more, in conclusion, Your Excellency, as Mr. Jussaran did not before this in his notes of May or April 22nd and June 10th last, of the high value my government would attach to the federal government's early accession to our request laid before it on August 29, 1913. Sign the agreement that you are going to relinquish extraterritorial jurisdiction in the French zone. This is what they're 3 letters they sent at them, trying to get them to sign it. The Secretary of State to the French. Now here comes the Secretary of State, July 24th, 1914. Sir, I beg to acknowledge the receipt of your note of July 16 in reply to that of the department under date of February 13, 1914, relative to the recognition by the government of the United States of the French Protectorate in Morocco, and the desire of this government for the settlement of certain questions affecting American citizens and American proteges. The American citizens are everybody else. The American proteges are the Moors and their rights in that country. The American government has assured the government of the French Republic of its favorable disposition towards the reform which the French Protectorate proposes, and will give the remarks contained in your note referred to above careful consideration. Accept it, etc. That was William Phillips, the French ambassador to the Secretary of State. The French ambassador comes back to the Secretary of State, November 14, 1914. Mr. Secretary of State, in continuation of previous communications, the last being the latter of July 16, last from the Chargé d'Affaires of France, relative to the claims in Morocco preferred by the federal government, which it thought had better be settled before extraterritorial rights were relinquished. I have the honor to inform Your Excellency that the result of the latest inquiries prescribed by my government concerning those claims has just made known to me, and I deem it my duty to impart it to you as follows. First, in regards to the word school case, it appears from the investigation that the claim formulated in this memorandum of May 7th last by the representative of the United States at Tangier, that it was settled as early as the following month of June. The deeds of sale were straightened out at that time. On the other hand, as to Mr. Rushkol's being given possession by his common law native vendor, the case is one that involves Mr. Rushkol and his vendor on one side and the German agent on the other. Until lately, it was for the native from the native from whom Mr. Rushkol held his rights to sue for the execution of the judgment rendered against his opponent, the German agent, before the consular courts of that nationality at Casablanca, and the Protectorate authorities were quite ready to facilitate, when the time came, the formalities required to enable the vendor, provided of course that he had previously secured an executor of the appellate judgment to give possession to Mr. Rushkol. The war declared by Germany on France, having brought German proteges. Oh, look at that. So Germany got proteges too, huh? They got Moors, subjugated Moors as well. The war declared by Germany on France, having brought German proteges under the operation of the common law, the execution of the judgment is now a matter for the local authority alone, to which the party concerned need only apply for a prompt and final settlement of this case. Second, in regard to the vacuum oil company's claim touching some land it purchased from one Ben Sauda, in which it is said the Moorish authorities will not allow to be sold because of the land being Haboo property. The legation of the United States declared in a memorandum on the case that it could not consider any settlement bearing on Haboo property to be applicable to its citizens and proteges before the forms required by Article 63 of the Act of Algeciras have been complied with. But in the opinion of the government of the Republic, the treaties of 1880 and 1906 could not bar the Sharifian government from amending or perfecting thereafter the laws and regulations existing at the time of the signature of those treaties. Article 63, cited by the legation of the United States, can hardly be invoked in this particular case since it deals with the examination of titles. So he's saying that the United States can hardly invoke Article 63. See, this is what it's about, invoking treaty provisions. And you see, they keep bringing up treaty provisions. It's all about treaties. Treaties are supreme law of the land, period. Examination of titles to Haboo property occupied under certain conditions by foreigners in 1906. And the present case is that of land purchased in 1913 by the vacuum oil company, upon which there seems to lie certain Haboo rights. There's 6% for Haboo properties. That's got to be paid yearly. It can hardly be doubted under the circumstances that the case in dispute is that of a land transaction, which, if it does partially or wholly concern the Haboo administration, must be settled with proper regard to the existing regulations governing Haboo cases. The Protectorate government has nevertheless asked the Haboo department to institute. We're going to need a Haboo department in AMPAG. We need to establish a Haboo department. Who want to write legislation to establish that department in our state? Let's think about it. The Protectorate government has nevertheless asked the Haboo department to institute a thorough investigation of the case, and the legation of the United States has been so informed. As to the various other questions, most of them of very little account, loss of an ox in 1911, the Banatul case, which can only be settled in accordance with the existing law, theft, the existence of which is not admitted, supposed to have been committed to the detriment of an American citizen, a money changer by trade, bearing the name of Muhammad bin Ali. Muhammad bin Ali is an American citizen. Let's read that again, hold up. As to the various other questions, most of them of very little account, loss of an ox in 1911, the Banatul case, which can only be settled in accordance with the existing law, theft, the existence of which is not admitted, supposed to have been committed to the detriment of an American citizen, a money changer by trade, bearing the name of Muhammad bin Ali. You think he's really an American citizen with that name? That's a Moorish subject. Well, he could be, if he chose American if he chose to be an American with a high, what do you call that, immigration status, I suppose. It might be an Arab. That name just looked very Moorish to me. But they're calling him an American citizen, a money charger by trade. He's not a citizen, an American citizen, not if he's a subject of Morocco. Bags of sugar, 10 in number, lost at La Roche. That is to say, in the Spanish zone, etc. The acting agent and consul general of France at Tangier has opened negotiations with the representative of the United States in that city with a view to reaching the earliest possible friendly settlement of these few questions. Friendly settlements, right? Learn to love instead of hate. The government of the Republic would fain believe that on the strength of the foregoing statements, which added to those previously submitted, are sufficient proof of the sincere readiness of the French authorities to bring without delay all these cases to a legitimate termination. The government of the United States will kindly, as it has repeatedly and lastly on July 24th, last intimidated to the embassy. It does says intimidated. Like I want to say initiated, but it says intimidated to the embassy, make a favorable answer to the request I have had the honor to present as early as last year, and to the effect that the government of the United States agrees, as has already been done by several European governments, to the abrogation, so far as it is concerned, of the capitulations in Morocco, wherever the government of the Republic has organized French courts. Be pleased, just arrived. Serge Black or Blake to the Secretary of State. American Legation, Tangier, December 20th. British Charge d'Affaires informs me that owing to Turkish intervention in European war, British government has proclaimed a protectorate over Egypt. A full agreement having been rapidly reached between France, Spain, and Great Britain concerning the international regime of Tangier. Great Britain consents to recognize the French protectorate in Morocco in exchange for recognition of British protectorate in Egypt. You recognize me for this, I recognize you for that. British legation, so you got your British legation, you got your American legation, you got your French legation. British legation here will be immediately suppressed, and the British charge will be appointed diplomatic agent and consul general. The question of the suppression of the capitulations in the two countries is reserved for ulterior discussion and forms no part of the present understanding. Italian, Spanish, and our own are the only legations remaining. It is possible that the international statutes of Tangier may shortly be presented for the consideration of the powers, but their application will likely be deferred until the ending of the war, as otherwise the international character of the community would entitle the expelled representatives of Germany and Austria-Hungary to recognize technicalities. In exchange for compensations elsewhere, all the powers, with exception of the United States, have now recognized the French protectorate. In exchange for compensations elsewhere, all the powers, with exception of the United States, have now recognized the French protectorate. I see no reason why we should depart from our position that that recognition of the French protectorate and the suppression of the American legation must be deferred until the settlement of our outstanding cases has been discussed. This point of view is well understood and seems to be admitted by the French local authorities as being both logical and reasonable. Blake, the end. That's the end of this document. And the end of the readings. What have we learned thus far throughout this session? Well, those who you may deem as your enemy, the colonizers, the Americans, the foreign Americans, they're scared of Moroccans. They ain't worried about Negroes, blacks, coloreds. They ain't worried about Moorish Americans. They're worried about Moroccans. They are worried about you, Moors, in the proper status as a Moroccan, utilizing Moroccan laws through what? Consular court. That's the reason why they naturalized us, and the 14th Amendment removed the word subject. Because with the word subject and us being subjects, they wouldn't have the ability to adjudicate against us, because we would be what's considered what? Plaintiff in error. Why? Because the subjects of Morocco, their jurisdiction is Morocco, which means if that's their jurisdiction, then they would need to petition consular court, which means then they won't have criminal and civil jurisdiction over you, especially if there was a consular court. So you had to go through what? The Moxon. But at this time, there weren't, did they have a Moxon here? I don't know, but I know it was in Tangier. The diplomatic body was in Tangier. So you have to petition consular court. They didn't want you to recognize that you needed to petition consular court. That's bringing you and keeping you too close to the truth of who you are and what this is all about. They needed us to know, or should I say believe, they needed us to believe that we came from Africa. And when did this whole African thing came out? Like in the 40s and 50s and stuff? W.E.B. Du Bois and Alex Haley, Roots. These are your Negro sellouts. Roots. Kunta Kinte. Some African that came from Africa with loincloths on to come do labor here. They were just snatched up by a couple Europeans, couple hundred Europeans. They just snatched up millions of, you know, Mandinkas, Africans and such. What's your name, boy? Kunta. No, your name is Toby. That was a fiction. But it served the purpose that even, you know, because what is the name? What is your proper status name? Right? Moorish subject. That will be Kunta Kinte. Negro, black, colored, African American, that will be Toby. Your other proper legal personality is Moroccan national. They applied the Toby to you, the Toby effect to us. That's the Toby effect. Negro, blacks, colors, African Americans, Moorish Americans, Afro Americans, Weave Americans, Dreads Americans, whatever kind of American, Aboriginal American, right? Anything else but Moroccan. We also find out that between the Moroccan government, as of 1956, the government for the kingdom in the United States made an attempt to strike the term or the Article 15, nationality article provision from the record. They wanted it to be obsolete. They wanted it to be found to be obsolete and without effect. But why? Why though? Why y'all going to such extent to do that? Why y'all, you know, of all the treaty provisions, it's in that same treaty, why that one and none other? Because they are afraid of us and they don't want to pay taxes. And they don't want to fall under our jurisdiction. They got used to where they're at, customs and usage. They have gotten too used to the system as it is with them in the driver's seat. But it's our system, and it's incumbent upon us, it's our obligation to take back the wheel. We got to steer this ship. We are the navigators, aren't we? We got to steer this ship. We got to take it back from them and start back steering this ship. And it's only going to happen through Moorish state governments, Moroccan governments, and Moroccan nationality and consular court, and anything dealing with Morocco. Anything outside of that understanding, you might as well just be a Negro, because that's what you would be, a subject, a Moorish subject. Ipso you're a Moorish subject. So it's 10 o'clock, past 10 o'clock, it's 10:13 actually. So I want to give you all a chance to ask any questions, make comments, open up dialogue. I yield the floor. You get something to drink.
Islam. I just wanted to quickly correct myself earlier regarding the servitude zones. It looks like servitude has to do with property law within Anglo-America, and it's a device that's similar to a trust.
Oh, interesting.
So servitude zones, based on what I read, seems to refer to something similar to trust property or trust land or something.
Okay, it's fine. Share that with me when you get a chance, okay?
Islam, it's in the chat.
All right. Anyone else? If no one has any other questions or comments, give you some time to get to it. Next week we'll be
Peace, brother.
yes.
Islam, one question for you.
Yes.
As far as the landmass is concerned.
As far as the what is concerned?
Sorry, as far as the landmass is concerned, can you hear me?
I can hear you, but I don't clearly understand what you was.
Sorry,
Okay.
the landmass that we're standing
Oh, the
on.
land mass, okay.
Land mass, I'm sorry, I speak so fast. Yeah, the land mass we're on right now, the earth. What would this be considered? Title,
What
as far
would
as
it
a
be?
continent.
A state.
A state, yes, but what's the name of the state? What's the title of the state?
You're talking about the entire landmass of Earth?
No, the Thailand that we're on presently right now. Your what's called flowers, the land of flowers, which they mistakenly call Georgia, and what's mistakenly called New Jersey territory, but it's titled as under America, North America, South America, Central, so on and so forth. So is it still called that, or is it called is it actually called a Mexim in Morocco? That's what I'm asking.
Oh,
Clarity.
yeah, let me say this. In studying international law and stuff,
Mhm.
I've been a lot of what the prophet had said and brought has been confirmed in my own studies. I've never seen a reference point for the term a Mexim,
Okay.
right? Northwest or Southwest. That's the only place that I've ever heard it and seen it is through the prophet. So if we were going to go from that understanding and that perspective, then yes, this would be Northwest of Mexim, Morocco, Southwest Mexim, Morocco, right? Or North Morocco, Central Morocco, South Morocco. We know that this is Morocco. The foundational name of it could potentially be a Mexim, right? Northwest of Mexim, Southwest of Mexim, and the islands. But as it relates to the treaties, it's Morocco.
So Treaty of Conquest, so it's America in Morocco. I should have seen a book with that
Is
too.
the United States of America is in
Yes,
Morocco, yes.
Yes, it's American America. So it's not going to be that whole Northwest South America thing is totally out the window. Then.
That's totally
That
out the
was-
window. Yes, totally out the window. So Brazil is in South America. I'm sorry, Brazil is in South Morocco.
Okay.
The United
And-
States of America is in North Morocco. Panama is in Central Morocco. Canada is in North Morocco. Argentina is in South Morocco. You understand what I'm saying? This is Morocco.
I got you. Now, all the adjoining islands, being that they are archipelago, would also be considered just, I guess, adjoining islands of Morocco in that sense.
Exactly. Jamaica is in Morocco. So it's North, Central, South Morocco, and the islands.
Now, as far as a reference point for that, or a reference, a map, because I've been trying to find maps that would substantiate it, and that's been the hardest thing to find. If they haven't burnt it or buried it somewhere, even the Library of Congress or National Archives, it's really hard to find, the provable, other than the treaty stating that having a map that substantiates and that supports it is where. Have you come across that as yet?
No, I don't think I have. And I might need you to repeat that again.
As far as a map, no problem.
Yeah.
No problem. As far as a map that delineates or points to that fact, that's the thing I've been having a hard time
No,
finding.
I haven't. I've seen some maps where you see the word Morocco. But I haven't seen a map that literally says where it says America, like North America, it would say North Morocco. South America, it would say, no, I've never seen it that way, no. And you probably won't see it that way.
No, even older maps don't even have America on it either. A lot of older maps, America is not listed on there as such. So it's just like just one blank slate, so to speak. But yeah, that's my comment, and I yield.
I appreciate that, good brother. And you can also find the maps. I've showed it before. The map of all the different protectorate. You had the Spanish protectorate, you had the French protectorate here in Morocco. So you had aspects or parts of it that was divided up that belonged to Spain. Then you had another one that was divided up that belonged to France, Great Britain. Morocco has been chopped up in a bunch of small pieces, and so many other different states have been claiming those pieces. But the relinquishment has been given up by all the way up until by 1937. All the foreign powers have given up they have relinquished their extraterritorial jurisdiction. The only one who's exercising it is the United States. Extraterritorial. Territorial is your territory. Extra means you are claiming or making an attempt to claim extraterritorial over on top of the territory that you have authority over. That's extraterritoriality, right? So they are encroaching over on into Morocco. That's what extraterritorial jurisdiction is, right?
Yeah, thanks. I just want to look it up again because I forgot what it was, but I'm going to look up on blacks.
Yeah.
One thing too, in regards to have you done the Treaty of Paris? Have you read over that yet?
I haven't done the Treaty of Paris yet, no. Oh,
Yeah,
well, the treaty, no, not the Treaty of Paris, no. The Treaty of Fez, yes, but not the Treaty of Paris.
Yeah, the Treaty of Paris is very interesting. When the first opening, something you should read over. The first opening
The preamble,
paragraphs, huh?
the preamble.
Yeah, well, not the preamble itself, but actually the body. I haven't read the preamble as yet. I got the actual treaty off the archives, the National Archives.
Yes.
And on there, when you read the first few sentences, it's very revealing because it pretty much states inside there that the United States is the property of, even after 1780, it was 1783, was when it was drawn up, and states inside it that the United States is the property of the British Empire. And they call Benjamin Franklin, late Benjamin Franklin, and late John Jay, and the late Quincy Adams, meaning that they were defunct and no longer in power. It's very interesting treaty to read over if you ever have a chance to read that one over.
Yeah, I will.
On the next treaty.
Islam. Thanks for the
Okay.
reference. Thanks for the reference point, good brother.
No problem, brother.
Yeah.
There you
peace and love. Another map too, concerning that you were talking about maps not too long ago. The exotic map of the United States is also another fascinating one. If you haven't seen that one, yeah.
No, I've seen that one. I
Yeah.
was going to show my sister that. That's really interesting because it's actually they even have maps. It's an overlay of the maps in present time now. Yes.
Correct. Yeah.
Even your territory down there, your republic down there, you have Montezuma, you have Arabian Mountains, you have Andalus farm in Sierra, a lot of and even in where's that place up there in where they had the what do you call those stones, the guide stones, Geordie guide stones. That particular area is where they have all the granite, and only a particular type of granite is the only place that granite comes from. I think it's a royal blue granite. It's the only place that granite comes from, and that's for pyramids, building pyramids. It's the only place that type of particular granite comes from. So that just proves that that whole Egypt thing is not what they make it out to be.
Yeah, right. Islam. Yeah, I mean, there's so many. I mean, the Grand Canyon is Egypt.
Yeah.
You find Egypt all in there, that's, the immovable objects, right? Huge statues and tombs, pyramids.
And all the mounds you guys have down there too. So there are a lot of mounds in that territory down there. The Republic.
What you talking about in Georgia?
Yeah.
The so-called Georgia. This is AMPAG now. They didn't know it was no longer Georgia.
No AMPAG, yeah, exactly. That's what it's so-called. It was the land of flowers at one point in time now, but now it's AMPAG.
Yes, sir.
Islam.
We do. The rock, they're made out of rocks and stone, Stone Mountain, etc. Yeah.
Correct.
Got a lot of mountains out here. Anyone else got a comment?
Yeah, brother, I was wondering if you could give us a reference point on those on the map that shows that split up the protectorate in Morocco. Can you give me a reference point on where I could get that?
You can Google that. Let me see.
Oh yeah.
Yeah, let me try to Google it. Let me go from what did I call it? What is it called? What was a good Google name to
Protectorate.
use? Protectorate.
The
Protectorate.
subdivision or protectorate.
French, but I should have said French protectorate.
Yeah.
Because there's been other protectorates. Move this out of the way. Where is it? Where is the French protectorate? This one is dealing with the one over there in Morocco, but that's not what we're looking at. We're looking for the one over here, right? That has France, Spain. Where is it? I might have Googled it wrong. Let me see. French protectorate map of USA. That way. This is one of them. See that there?
Oh wow.
You got New France, New Spain, and then the British colonies. That's the France. You see how much France got? And guess what it includes? Louisiana, of course, right? Because Louisiana is very French-like. And then Spain, which includes all the stuff, Mexico, all that stuff going down south, the southern to that, even Florida. This is another one.
Where's that map? If you're not, where was that map?
I actually like this one better.
What's the time frame on that map?
The title of it?
The time frame. Sorry, the
Oh,
time
the
frame.
time frame? Good question. Let's find out. It should be in the 1800s, no later than the 1900s or early 1900s.
And what was your search term, brother?
Oh, it says here circa 1700. You see it?
Whoa.
Yeah, circa 1700. What was the question,
Wow.
brother?
What was your search term?
Oh, French protectorate map of USA.
Okay.
Seventeen hundred. Because a lot of the conquest took place before the Treaty of Peace and Friendship, before the Treaty of Fez. You know, the empire had been going through all different types of turmoil for quite some time. Remember, remember the date that we took the first fall? 1492. Way back then in Al-Andalusia. And it finally started manifesting fully throughout the whole empire over here. The land of milk and honey, Turtle Island, right? It didn't start manifesting over here in these dominions until around the 1700s. Through the all the paper bulls, Intercadena Catera, etc. Vienna, the secret treaty of Verona, all that. Yeah. Got something to drink. Give me a second. I'm back. Yep, that's the map. And that's the story. So I don't know where this is why the whole story of coming from Africa and all this stuff is BS. We've been here the whole time. What did MLK say? The Negro is languishing in American society where he found himself exiled at home.
An immigrant in his own land.
Yep. But in our own land. So all this Kunta Kinte talk, all this Shaka Zulu talk was BS the whole time. That ain't even our culture or our swag. We're more like Aladdin, the baggy hammer pants, right? With the fez and the scimitars and the pantaloons, not loincloths and spears. We weren't African booty scratchers. We were Moors, Moroccans. The prophet said, look at me. This is how you're supposed to look. This is your culture. This is your swag. This is your style. Garbs, you know, Moorish garbs and headdresses and such, turbans and fezzes, and you know, that's our culture. So they had us wearing dashikis and picks, Afro picks with fists on it, and jerry curls and soul glow, and they just had us all over the place. But you know, the funny thing is the hip hop generation, the first generation or the first few generations, the young fellas at the time, what was the hairstyle that represent the fez? Y'all remember? Look just like the fez.
The Gumby?
Oh yeah.
Yeah, but no, that's not the name. The real
The
name.
high top. The high top fade.
The high top fade.
Yeah. Yeah. With the step in it, the Bobby Brown.
Some even had the ponytail at the back. That was that represented the tassel.
Wow.
Yeah.
That goes 360 degrees.
Yeah.
While the Shriners, they're pinned at 33 degrees. You know, we're 360 degrees. Yeah, hairstyle. Even, you know, did you imagine what these people was like? Wow, they have cut their hair in the shape of a fez. Oh my God, we got to intensify this operation. You know what I'm saying? naturally by nature, you know. That's what we did. We're not kings of Zamunda. We're not coming to America. We were already in America, misnomered as America, in Morocco. That is something else, man. You know, they really put us in it, like the trick bag switched by the season. It went from Africa to Moorish American. So they think they're Moors. They got that figured out. Okay, let's put another trick bag in that one. They're Moorish Americans.
Wow.
And then we
Yeah,
took
I like
on
that word Moorish. Ish.
You say you don't like that word Moorish?
Ish. The ish. Yeah.
Yeah, I know that's what you were saying. It's all through the treaties though.
Yeah.
It's all through the treaties. Let's type up ish. Everybody say that and I don't understand it. So let's type up ish. Why? So do you mind for white people or whoever else to call themselves British? Is it okay for them to call themselves British? It's an Irish
kind of something. Irish.
Is it okay for Irish to call themselves
I guess
Irish?
you can, yeah. You look at it that way, yeah.
So why can't we call ourselves Irish?
I got you. I got you. I'm higher you on that.
Yeah. Let me see. I'm looking for I want to give you a reference point. Right here. Merriam-Webster's dictionary. The definition number 1. Can y'all see my screen? Of relating to or being chiefly in adjectives indicating nationality or ethnic group. That's the first definition. Now we can go into boyish, characteristic of boyish, right? Inclined or liable to, having a touch or trace of, having the approximate age of 40-ish. I'm in my 30-ish, right? So all those definitions, they apply to ish, but what is the first one though?
Yep.
Nationality.
Related to nationality.
Nationality.
That's what it matters.
That's all that matters.
Yep.
And then not only that, but then how do you identify Moorish customs, right? So like culture, right? So like our architecture. What would you say? More architecture? That would be good, but it would be like weird, right? It would make most sense to be Moorish architecture, Moorish garb, Moorish whatever, the Moorish people. You know, so yeah, so ish, either way denotes or it indicates nationality.
Yeah, I get you. This sounds the first. Yes, we stick to the first definition.
The very first definition, yeah, not even the second or third, the first one, and then everything else come after. So
Right.
that nationality is always the order of the day. No, across the globe. So that's how come you can be an Irish or British, Swedish, right? But then you could also be, you could also be a person, a grown man could be boyish. You acting boyish or girlyish, right? How old are you? I don't want to tell you my age. Come on, man. Tell me your age. Okay, I'll tell you what. I'm in my 40-ish. You know, so ish is a word that can be used in many ways, but obviously the number one definition and the number one usage of it is based in the highest understanding, which is nationality. Nationality is the order of the day, y'all. So Islam, I hope I cleared that up, the ish thing.
100%.
Islam.
One of the things that I noticed in reading of the treaties, you know, I always throw those words in. There was one that you dealt with tonight. I put it in the chat, palliation, right?
Thank you.
The way he came with the way the charge the affairs was coming at Secretary of State for the United States, he said something to the effect, I'm sure you will find all the palliations that will suit your needs. And when you look at that word says the act of palliating or concealing the more flagrant circumstances of an offense, right? Crime, etc.
See, I should have looked it up when I was reading it. I should have looked it up when I was reading it.
Yeah, I put it in the chat while you was reading it, man, because it lets us know that there was a confederacy among those who, as you called it earlier, the light-skinned Arab, right?
Yeah.
There's a confederacy among the League of Nations, right, that came in and said, we're going to colonize all of the Moorish territories in this empire. And you called them South, Central, North, Canada, Portugal, Brazil. All of those were Moorish lands. All those are indigenous folk land. And those powers that be that came together with the League of Nations, now this is just, from my study, they all agreed that they would, as it says, palliate, right? And they conceal a whole lot of things through language. They took full advantage of the language divide, and clandestine words and contracts, or elements that they put in contracts that was ambiguous. If it wasn't corrected, of course, we know that we were civilized, and the government, we knew government, right? That's why everybody was wanting to sign treaties with us. But the Americans, as we see, has always been the worm in the apple.
Right.
Even to this day, they're the only worm right now in the cherry, so to speak. You know what I'm saying? So right now, they're the thorn in the flesh that has to be removed.
Right.
And once the 13, as you put it, once the 13 states, provincial governments come together, then decolonization, or at least the beginning of the claim to the UN will stop.
That has to be done with a proper claim. And what I was saying about I'm glad you brought it up, the Pale Arabs. Look at what this says for the Treaty of Madrid. The Treaty of Madrid 1880 was a collection of agreements between Morocco under the rule of Hassan I and many European powers to give the powers the ownership of Moroccan lands they had seized. The resources present on these lands, settlement rights, and employ locals on these lands. Who are the locals? The Moors, the Moorish subjects, the natives. This treaty served to regulate and make these conquests official in the international community. You see that? Yeah. So, and even with that, they still had Article 15, which was the nationality clause of the treaty, which is choose between the submission of the laws of the empire, amongst other protections. So subjects still, the Moorish subjects still had protections, but they still were. It still served as a document to confirm the subjugation from the lands that were seized from the foreign powers. Interesting, isn't it? So yeah, so that's why you would think, or you would say, you would see in your mind, like Hassan. You see what Hassan looked like?
What now?
You see what Hassan looked like. That is Hassan I, Hassan bin Muhammad. It was under him that this treaty was put together. Are you seeing his picture? Am I sharing the screen?
No, see it. I see got the picture for that.
What was that?
No, it's not seeing that. Seeing looks like a prediction. Oh yeah, see it. Yes.
All right, let me just click on it.
Yes, I see it.
It's here. See it.
Let me click on it. Yeah, let me click on it and bring him
So I
up.
blow it up. See it.
Yeah, there you go, right there.
Yep.
Right here on the right. Hassan I. Look, reign 1873 to 1894. That he was the one. So it says, let's see what it says here. Al Hassan bin Muhammad, known as Hassan I, born in 1836 in Fez and died on 9 June 1984 in Tadla, was a Sultan of Morocco from 12 September 1873 to June 1894 as a ruler of the Alawi dynasty. He was proclaimed Sultan after the death of his father, Maulai Muhammad bin Abdul Rahman or Rahman. Mali Hassan was amongst the most successful sultans. He increased the power of the Maxin in Morocco, and at a time when so much of the rest of Africa was falling under foreign control, he brought in military and administrative reforms to strengthen the regime within its own territory, and he carried out an active military and diplomatic program on the periphery. He died on June 4, 1894, and was succeeded by his son, Abdal Aziz. So he died in 1894. And his predecessor was Sidi Muhammad IV. This is, you know what I mean? Like, this should be like second nature history. Like, we should know all this stuff. Like, we should know all the sultans by memory. We have no idea who none of our sultans was, and we are the Moorish, the Moroccans. Ain't that something? We have been taken all the way out of our proper person, and been reduced to 3/5 of human beings. Effectively, they've done that. There was an effective move on us in that regard. It was effective, very effective.
But that took us to do that too. It wasn't just them alone. We had to be involved, and some of us had to be involved in that too as well.
Of course, it took us to make that happen. Without us, that wouldn't have happened. It wouldn't have been possible. We had a lot of help from our own people.
Still getting it.
Still getting it. So when you talk about the devil, who's the, you know, they call white people the white devils and all that. Well, ain't nothing worse than a black devil, I tell you that.
Ashe.
And I'm not calling white people devils at all. We're not.
No.
That's not a thing.
Okay.
That's another distraction and misinformation.
Misdirection.
Misdirection. Yep. Major. So, all right, it's 10:45. One last comment or concern, question before we close out. Some of the Moors got to go to the Job in the morning.
Excellent session, brother. I enjoyed it.
Islam, gratitude. I appreciate that. Thanks for those kind words. We'll have another one. Islam. We'll have another one next week. I'm assuming that iPhone is Brother Joel.
That is me. Yeah, it doesn't change what I do. How do you know?
The voice.
I got
The
you.
voice. Yeah. But thanks for showing up, Brother Joe. Thanks for showing up, Brother Shamu, and everyone else who showed up. I hope you all enjoyed it and learned something here. I hope the real takeaway here at the end of the day is we're not Americans. We are the Moroccans, and that's their pain point. We got to push that pain point. We have to put pressure on that pain point if we want to win. With all the confusion that's taking place, with all this drama in the LBC, with all the confusion in Morocco, with Moors not knowing who they are, these treaties, even if you might not believe fully in whatever. First of all, what's wrong with being a Moroccan, right? You know, like, it's not saying that you're the devil. Like, get over it. But even if you don't believe that, even if you think you might be whatever else, we at least have identified the Europeans' pain points. So why don't we just all focus on one destination and ride it to the final destination, on one goal and ride it to the final destination, right? So that we can get away from the confusion that we've been dealing with, because the confusion is what's been keeping us in a perpetual state of delaying our own justice. We have to, so in order to find our own justice, we have to find the truth of who we are and what are the instructions to establish our salvation, right? So if we look at treaties, if we look at these United States documents that I pointed out, obviously it's all about Moorish subjects, Moroccan subjects, proteges, or that would be in your subjugated state, right? In your subjugated state, you are a Moorish subject, Moroccan subject, or Moorish or Moroccan protege, subjects and proteges of the United States, subjugated Moors. In your old capacity, ancient capacity, when the empire and the monarchy was still in effect, it would have been subject of Morocco. Today, the modern nationality would be Moroccan. That's it. Moroccan national. Real quick. You see, this is our ID. Can you see this? You see what it says right here? Nationality, Moroccan. Nothing else. Now, if you might be a Cherokee or something, there's a third flag here to represent whatever other tribe that you may be a part of. But the prophet was a Cherokee. He didn't claim Cherokee. He claimed what? Moroccan. So I guess to conclude, in conclusion, we need to take the identity of the Moroccans, which is our identity anyway, and through it, establish our state governments, through which would establish your consular court, through which you can send out consular court orders. That process, along with legislation, is how we will be able to force the colonizers under our jurisdiction through what would be called decolonization. The end result, the goal of this entire movement, AMPAG, and New Mecca, and any other state coming online, the goal, without a doubt, without any deviation, is decolonization. And what does it look like? Taking back the system that's currently in place and put it back under our jurisdiction, our authority, our control, our management, our governance. With that, I close. Peace and love, everybody. We'll talk to you next Wednesday. I'll send out links and stuff for whatever we'll be talking about next Wednesday. Peace and love. Thanks for showing up, everybody.
Peace and love.
Islam.